All right, why don't we get started? It's 9. Clock's a little slow. What we're doing today is calling a trial calendar that will begin on the 15th, meaning that's next Monday is when we'll pick a jury for whatever case goes out, which gives everyone a few days to get ready based on how today plays out. I think we have a few pleas to take today, and then flowing from however the call of the calendar goes, we will be able to figure out who needs to come back on the 15th for trial. Position 1, Ms. Grant was reset. Ms. Feely, you excused Ms. Grant?
Yes, thank
Good.
you.
Okay. Positions 2 and 3 have been put on judicial hold. I don't know if Mr. Cherry's back to Clayton, but we have been working with Clayton to say, you should come get him. And then I'll just ask you and Mr. Jordan or Mr. Peoples to be keeping track of that one, because if something happens in Clayton such that we should bring him back here, let's do it. But the Clayton situation seems a little more serious, and I keep hearing rumblings that there's something in Florida as well, but I don't think that's materialized quite yet. That gets us to position 4, Anthony Johnson. Is Mr. Johnson here? Ms. Willingham, I know when we talked about this, Mr. Jones did file whatever he needed to file. So we won't be going forward with it, but Mr. Johnson's out on bond. I think, unless something funky happened, and Ms. Nelson will remember, I think he actually had a situation in Arkansas and was sent to Arkansas once he made bond here, and then got bond in Arkansas. So I'm hoping that he appears in some way today, because he's supposed to. But regardless of that, we won't be going forward with this case on this calendar because of Mr. Jones's leave. That gets us to Ms. Brinkley. Is Ms. Brinkley here? I had heard that Mr. Matthews was actually going to be available this morning, despite his long-running obligation with the YSL case. So I'll have Ms. Nelson reach out to his office. Ms. Brinkley needs to be here regardless. So we'll see how that plays out. Let me make a running list here. So Johnson, 5. All right. Keith Berry.
Mr. Berry is in custody. I spoke with him on Friday. I believe we'll have a plea on 6 and 7, as well as another pending case, 23 SC 185844.
Can you say that again? 23
SC 185844.
Okay. Are we pulling that from non-complex, or it's got assigned to us? It just is early in the pipeline.
Right. It got transferred to us already.
Of course it did. Okay.
He will wrap up all 3 of those hopefully today.
Okay. I'm assuming he's here. Deputy Gordon told me that they had 9 folks here, so I'm assuming Mr. Berry is one of them. Do you need to talk to him, or this is what's happening, or how should I mark this down?
I can speak with him, just make sure he's good to go.
Okay. 6, 7, Berry. All right. If for some reason that's not what happens, I think you all told me both sides are ready, and Ms. Willingham, you'd want to go out on position 6. Okay. All right. Then we get to Ms. Diaz-Ortiz and Mr. Pitts. I see Mr. Kane here. I bet Mr. Pitts is here. They may still be bringing people up. And I don't see Ms. Kaufman.
She's on the way.
Okay, good. And Ms. Ortiz is supposed to be here as well. That is how we left things with Ms. Kaufman. So what is your announcement, Ms. Willingham, as to what's happening with Pitts and Diaz-Ortiz?
We are still trying to.
Oh, there's Ms. Kaufman.
We're still trying to get our.
Hold on one second. Ms. Willingham is giving the announcement in your case.
We are still trying to get our victim. I know that it is on the calendar for Monday, and if we not find her by that time, then we will do what needs to be done at that point. But for now, the state is still ready to move forward.
Okay. Mr. Kane, I won't make you stay around unless you want to talk with Mr. Pitts or you want me to share something with Mr. Pitts.
No, I want to share something with you.
Okay. It's a sharing day.
We like those days. I understood that Friday was the drop dead date for the state to let us know what they're going to do if they found Ms. Glover or it's Monday morning. You put a judicial deadline on this case, our last calendar. So if there's no complainant, my phone call victim, Ms. Glover, then I think the state should move forward and docket the case.
Okay.
Otherwise, what do we do?
So I hear you on that. I can't compel the state to do that. And what Ms. Willingham just told me is she understands that Mr. Pitts, well, this is how I heard it. These weren't her words exactly. Mr. Pitts has been in jail for a long time. So this is likely the case that I would prioritize for trial next Monday. And if the state doesn't have Ms. Glover, then I don't know how they could go forward. But there's still a week.
Okay, well, so if you're extending the term for the state to respond, you have it by Friday, so I know what to do for Monday, if the state does.
So you and Ms. Willingham can sort out what you want. I would certainly ask Ms. Willingham to keep both of you posted, but I can't null pros a case.
Actually, I understood. You said at the last calendar, Friday was the date, Ms. Willingham was to let us know, for Monday was the call.
Okay.
Now I understand what you're saying. The state has till next Monday to come up with Ms. Glover. So I'm asking you, could you ask the state to let us know by Friday what they're going to do? So that I'll know what to do Monday.
Okay, please.
Maybe there was a misunderstanding, because I was under the impression that we had until we get ready to pick a jury on Monday. And if at that time the state doesn't have anybody, obviously we do not proceed forward. And yes, I will keep them posted as best I can. If I know for certain by Friday that there's no way we're going to get her here on Monday, then I will let them know that. But I was under the impression that we had until that point in time. And if I misunderstood that, then by all means, I will try and get with the supervisor to get an answer for you today.
No, so I think I may have been imprecise in the language that I used. What I'm remembering is that I had asked you, Ms. Willingham, to let the lawyers in the case know by Friday, meaning last Friday, where you were in the process, found her, haven't found her. And I'm gonna have you do that again this Friday. Mr. Kane is saying the right thing. I can't force the state to do one thing or the other. But if you could please let both Ms. Kaufman and Mr. Kane know, as this week is wrapping up, if there's been any change in the state's ability to find Ms. Glover. But again, it's not until I say, great, let's bring a jury in for State versus Pitts that you would really be forced to say, well, actually, that's not something that we can waste 60 people's time on. So, Mr. Kane, I know that's suboptimal for you because you're left like, do I get ready, not get ready? I get it, but what I'm not interested in doing is continuing this one again. Mr. Pitts is sitting in jail, and so I view this as the proper pressure point that I can push on for the state to say, we're going to trial on the 15th. And if you don't have Ms. Glover, you can either try to move forward without her, or you can say, I'm not going to dead docket the case. They'll need to null pros it. But I think Ms. Willingham understands the crossroads she'll be at. I just can't say, hey, you know what, actually tomorrow you need to make that decision because I'm not bringing in a jury tomorrow. So I appreciate that leaves you with uncertainty. Other than that, you've known for a while that May 15th is a trial date that you ought to protect from other commitments that you have.
Understood.
Okay. So Ms. Willingham,
Back here next Monday.
Yes, I will send an email out to all the lawyers whose cases are on the Monday shortlist. Today, other cases are going to resolve, but you're hearing me say that Pitts and Ortiz will be at the top. And Ms. Willingham will be keeping me as well as the two of you posted as the week progresses. Success, no success with Ms. Glover.
Let me qualify that. Am I here Monday in the event the state calls me Friday and says they have a witness, but if the state calls me and says they have no witness, do I have to come Monday? Am I excused or?
Well, I guess you'd need to see what Ms. Glover has to say. She may say we don't have a witness, but we're still going forward. And then you come on Monday saying this will be an easier trial for Mr. Pitts. But it really depends on how Ms. Willingham frames it. But I can't remove next weekend as a chance. But it may be what you hear on Friday is, oh, we found her and we are figuring out the material witness warrant. You know how these things evolve on the few days leading up to trial. So I'd like to give you more certainty. I'd like to give me more certainty. But that's where we are. Okay. Do you want a chance to talk with Mr. Pitts today?
No, I was to the jail, so.
Okay. All right. So we can send Mr. Pitts back down. All right. Thank you, sir. And I think Ms. Ortiz just walked in. Hello, Ms. Ortiz. Thank you for being here. You may have missed some of the exchange, but the ball's still up in the air as to what exactly the state's going to be able to do a week from today. I'm going to ask you to sit tight just because I think Ms. Kaufman and I may need to talk a little bit. Okay. All right. Thank you. So a few people walked in. Did Ms. Brinkley come in?
Yes.
Hey, Ms. Brinkley, how are you? I am glad you're here. Any word from your lawyer, Mr. Matthews?
I was told that he will be here today.
I was told that too.
Yes, the secretary called me on Friday and she was like, he'll be here. He might be running a little late, but he will be here.
Excellent. Then I'm gonna ask you to stay here. We'll work the phones to see where he is in his ETA. But my understanding was that maybe your case had been worked out. Good, but we need Mr. Matthews to close the loop on that. So please stay here. You're welcome to step outside every once in a while, but don't leave the courthouse for good until we've either resolved your case or we receive word that Mr. Matthews can't be here because of X. I hope it's not the second one.
Yeah.
Okay. All right. And Mr. Jordan, your understanding is that this case will be resolved today.
I believe so, Your Honor. I tried to contact Mr. Matthews over the weekend just so we could hammer things out, but I believe
Okay.
we're at least close.
It's a little wishy-washy.
Yes,
Okay.
Your Honor.
We'll see what happens. Did Anthony Johnson come in? No. All right. We'll try again on that one. But Ms. Brinkley comes off that list and we'll put her over here. All right. That gets us to Morris Horton. He's here. All right. Hi, Ms. Wood.
This is a plea today.
Excellent. Mr. Horton, we will get you lined up for resolution today. Please don't leave till we do that, okay? Thank you. Tiana Smith. Hey, Ms. Smith.
This is the one that was a diversion referral. I need to just go over the specifics with her this morning, but I expect that's how it will resolve.
Okay, and what will I see? Some paperwork from pretrial diversion or from Ms. Feely?
Your Honor, what I believe the usual course is I would submit a order for judicial hold, which I already have typed up and ready to send to Your Honor, pending Ms. Smith accepting the program. I would just submit that to Your Honor, and the case would be placed in judicial hold. If Ms. Smith did not complete the terms of the adult diversion program, we would just ask that the judicial hold be lifted.
Right, and we reinstate the case and we move forward. I just was wondering, but we think today you'll be able to submit that order, assuming it sounds like Ms. Feely and Ms. Smith need to talk a little bit, but we should be able to close the loop today such that you can send me that order today.
I haven't typed up.
Great. And that order lists all of the expectations, or it simply says you'll do pretrial diversion?
It It says, Your Honor, that she'll do pretrial diversion and that the state would move to remove the judicial hold lift if she does not complete the terms of pretrial diversion. If Your Honor would like me to specify more in the order, then I definitely can.
Well, the only reason to do that would be if there's some concern about what those terms are, or if Ms. Smith 6 months from now says, well, I've done everything, and someone from pretrial diversion says, well, you were also supposed to do community service, and the order doesn't say that. So typically, the order lists the requirements so that the state's able to enforce it line by line, or similarly, the defendant's able to say, well, I did all these things. Why do I not have the null pros?
I have all specifications of the diversion program, Your Honor. I can put those in.
Great, thank you. Okay, that gets us to number 12, Mr. Camden. I think he was brought over. I know this is one where Ms. Hall has asked for a continuance. I'm inclined to grant that. It will be over your objection, and I'll make clear of that in the order that I entered. I just wasn't able to do that this weekend.
Understood. And if we could keep Mr. Camden here, he's another one housed in Cobb. So if I could talk to him before he leaves, just so he understands.
Sure. Mr. Camden's here? Great. So we'll leave him here until you let Deputy Gordon know you're done with him. All right. 13 was a plea. John Davis should be here in custody. And Ms. Feely, you had said you were ready. Was this a medical record situation?
No, Your Honor, just one of the witnesses has 2 open cases, and we have not been able to speak with him yet.
Right. Okay, but that's 2 open cases and you don't know where he is, or you have to work through a little lawyer?
He's out on bond, Your Honor. We do know where he is. We just have to work through. I believe he may have a public defender on both cases.
How do we not have a conflict?
So I think we would. Both of his cases, he bonded out really quickly. So I'm not sure anybody from my office has spoken with them. There may be a name listed in a first appearance somewhere, but.
Okay. And how would that conflict play out? Would your office, Ms. Feely, need to roll off of John Davis, or would your office need to roll off of witness with 2 cases?
The second one.
Okay. And then we just need to get counsel appointed for that witness.
Yes, sir.
Okay. All right. So state remains ready. Defense remains ready, and we have to navigate this other situation. So I guess if you could, Mr. Jordan, look into Odyssey, because I don't know this person or what the cases are, to see what the representation situation looks like, and let Ms. Nelson know. And then we'll do what we can to get sort of emergency C2 representation for that person. Is that person an eyewitness, an alleged victim, or found the gun somewhere?
He is an eyewitness, Your Honor. I believe that he is, he may be the biological son of the defendant.
Okay. Got it. All right. But your sense, Ms. Feely, is that your office would stay on Mr. Davis's case?
Yes. And I don't know if this throws a wrench in any conflict appointments, but one of the cases appears to be a misdemeanor.
It is, it's attached to a misdemeanor. Are you talking about the?
Pistol?
Yes, the pistol. So there was one case for him, Your Honor, Mr. Thrasher, that's on the state's witness list. He has a misdemeanor possession of a weapon under 18 years old, and he also has a theft by receiving stolen property. Those 2 cases seem to have been separated for some reason, with the misdemeanor staying in state court. The theft by receiving stolen property, since the weapon was found to be stolen, it has an order of dismissal, but it's still pending for some reason.
Okay.
So I at least believe that's still technically an open felony that he has.
It sounds like either way, he needs counsel to help him navigate what testimony would be like.
Yes, sir.
All right. Mr. Matthews, good morning.
Good morning. How are you?
I am well. Appreciate you being here. Ms. Brinkley's here. We chatted briefly and she let us know you were on your way. I'm going to get through the calendar. We're almost done. And then I'm going to ask Mr. Jordan to start with you so that we can take care of, if we are able, Ms. Brinkley's case because I know you've got to be in another space soon. Yeah, so we're going to use this window. You're one of your few windows. So that's how that'll flow. Okay. So I'm putting Davis on the list of cases for trial, and then we'll see what we can do to get a lawyer for Mr. Thrasher. Is that the last name?
Yes, Your Honor.
Okay. All right. Lawrence Jones, not on bond, right? And that was ready. Anything change? You and Ms. Willingham hadn't connected on some of the cases you have.
And we since have, and I believe this will be a plea.
Okay.
I need a moment to speak with him.
All right. Well, to be clear, we've got all day, so
Thank you.
we can do that. Ronald Richardson. I didn't write anything down next to him.
He was the one, Your Honor, the medical records.
Oh, right. Okay. And then he's got 2 CP cases as well.
Correct, and we were trying to reach a global resolution. I needed to make contact with the victims on those CP cases. I didn't do that until late, so I did get back with Ms. Ely this morning. Obviously, I wouldn't imagine she's had an opportunity to speak with you today.
Okay. And the medical records, some of them you're pretty sure you could get because they're Grady,
Yes.
but some of them are not, and you were not so sure how quickly those could be obtained.
Correct, and my investigator has reached out to try and get them. I will follow up as soon as we're done with the call of the calendar to see where we are on that. I know Friday she still hadn't heard back regarding those.
Okay. Well, I'm happy to lend a hand if you need an order to pry those out of a provider. In this day and age, it just, you type some and then you print it out. So it shouldn't be real burdensome on the medical provider. All right. Ms. Feely, you're going to talk with Mr. Richardson. Does it sound like there is a potential negotiated solution, or what you heard is likely not to make Mr. Richardson's Monday morning?
I don't think it could resolve today based on our conversation on Friday.
Okay. Well, I don't mean necessarily this morning, but do you think this week or this, you guys are pretty far apart, and I ought to put this on the trial list?
I think we are pretty far apart, but we will, obviously we have this week to continue working.
Okay. I think I asked this before, Ms. Willingham, of the 3 cases indicted and the 2 unindicted for Mr. Richardson, the most serious charges are the indicted, or are one of these unindicted triple homicide?
I would say they're kind of
Similar? Okay. All right. Do they involve the same alleged victim? There's 3 counts of aggravated stalking in this case. I don't.
So these are 3 different victims. One is the reason we have it in DV, but those are not the same victims from the unindicted ones.
Okay. All right. Thank you.
So I was a little harder to get an answer.
I bet. All right. Mr. Hall, we had to continue because of the late stealth immunity motion.
And I also didn't know who I needed to put on this on their radar, but this was also the case that we had the bond hearing where there was some.
Yeah,
confusion.
it's on Ms. Nelson's radar. And so she reminds me every time. She'll say, hey, that's the case. I'm like, well, what case? And then she says the one where, you remember Mr. Hall's case, Deputy, this is when the courtroom blew up and you guys had to do your mano a mano stuff. Yeah. So if for some reason, I think I'm hearing the immunity motion because you may have been fudging it, but you said it won't take too long. So we didn't send it off. We've got a judge who's hearing a bunch of immunity motions to just free up our time to do other things. But I think I'm keeping this one, which is probably better just because we've got that intel about how it got a little bumpy. Okay. Positions 18, 19, and 20 were null prost late last week. Did anyone get brought over on that one? Okay, good. So if anyone wants to see, what was his name? Baby Drill? I think that's his professional name. Baby Drill is back performing live, no restrictions, if you're into Baby Drill's music. Made Sony Records very happy. All right, Ms. Gonzalez pled, Mr. Bruce, those misdemeanors were null prost. Mr. King, 23 and 24, I have down that's going to be a plea.
Yes, Judge.
It still is. How you doing, Mr. King? Great. We will do that today. Position 25 is Mr. Hill. Ms. Pass, I see that you have joined the call. Are you able to hear me?
Yes, Judge.
Hey, we have to continue this because of your medical leave. And so I wish you the best with that, as does Mr. Shapiro. This case is also on the consolidated criminal trial calendar that we're running in Fulton, where judges can submit for a senior judge to try. It's at the very end of that calendar. It likely would not go that first week, which I think is still part of your emergency medical leave. It could go that second week, but I will be keeping you, Ms. Pass, and you, Mr. Shapiro, posted on that. We're last. And so if anything else is going that second week, that would go ahead of Mr. Hill. And so if we don't get reached on that consolidated calendar, I'll probably try to specially set this because I know the state has some out-of-state witnesses. And Ms. Pass, you've had some scheduling complications. So I hope most of all that you are doing better medically and that you continue to improve.
Thank you, Judge. I am. I was able to do a trial, and they're trying to kind of set them apart so that I can start getting some of these trials out of the way. So I'm doing a lot better. Thank you. Getting a flat tire in the rain today didn't help, but
I bet.
what is the last week of that?
Say that again.
What's the last week of the consolidated trial calendar?
The week of the 22nd. So the consolidated calendar starts next Monday. And Mr. Hill's case will not be reached that week because, again, any other case on the calendar would be out ahead of it. But it's possible that it could be reached on the 22nd. What's more likely is that it would make the short list. And so you all would be ready to go on the 22nd. But if cases ahead of you didn't plead out, then it wouldn't be reached. I'll try to make it as certain as I can because I know they're moving parts. I also think, Ms. Pass, you've got Fridays off for medical reasons.
Well, Judge, I've been moving those. My nurse can come on Saturday so that I can get, because there's no way a lot of these big cases are going to be able to be done in 4 days. So I've been able to move those as long as I have advance notice. It's not an issue.
Okay, good.
And also, I do have a specially set murder case in Rockdale on the 22nd. That's definitely going. He's in custody.
Oh, well,
And
that
it's from
would,
like 2000, it might be 20, maybe.
okay. Do you have that case number?
Yes, Judge. It's Judge Beals. Hang on one second. Let me. Trying to, so I don't hold you up, Judge. I can find it and put it in the chat.
Great. If you would do that, then we'll confirm with Judge Beals. And if that's a for sure thing, the week of the 22nd, we can't do Hill. I'll go 0 for 2 on that calendar. But such is life. So yeah, please send us the case number. What's your client's name?
Ashton, Ashton, Denny, Denny.
All right. Okay. Thank you.
All right, I'll put that in the chat.
Great. Once you do that, you're free to go.
Thank you, Judge. I appreciate it.
All right. Positions 26 and 27, Mr. McCoy, I heard those are also pleas,
Yes.
correct? Great. 26, 27. McCoy. And then we have one case on the supplemental trial calendar, and that is Mr. Lloyd. And I heard that may be a plea as well.
To be a plea, Mr. Jordan, I had a conversation with people that I want to fill you in on.
Yes.
I think I saw Mr. There he is in the flesh. Excellent.
All right.
Morning.
Scratch that. We can have it. It's a non-negotiated plea with the cap, Judge.
Okay. We will do that today as well. And Mr. Lloyd is here. What I think we're going to do then, gosh, it's not much left for the trial calendar. Better get Mr. Thrasher, a lawyer, and those medical records in Richardson. Is there anyone here who didn't hear their name called? Did Anthony Johnson show up? No. Okay, that's our one no-show. Mr. Jordan, if you would please speak with Mr. Matthews to see if you can iron out what you need to iron out with Ms. Brinkley's case. I will come back out here to start with that plea. And then I guess I'll ask the rest of the lawyers. I think it's mostly Ms. Feely and Ms. Wood, although we do have Mr. Melnick. I can take these other pleas in whatever order you want. We have a hard stop around 10 to noon. I have to go pick up my kid and bring him back here. It's exam week. So he'll be here in the afternoon. But that's it. So we can take pleas as they are arranged this morning. Whatever we don't reach, we will do at 1 o'clock. I just have to go extract this guy.
Was there anything that you wanted to discuss with me or my client? Because I know you had said that you thought there were going to be further discussion.
Oh, no, I don't. Well, I did say that. I just wasn't sure. So I guess I know you and Ms. Ortiz are as much up in the air as Mr. Kane and Mr. Pitts are. There's the added complication that, of course, Ms. Ortiz would need to be here next Monday, and she comes from Pennsylvania, not from Paulding County. I was trying to come up with a P that was nearby. It's closer than Pennsylvania, or West End, but just doesn't start with P. So I guess let's just continue to stay in touch, the three lawyers and me, over the course of the week. So we've got a sense of how Monday will go, because this will be what I expect to be first out if it's not otherwise resolved, so that we keep that pressure on. It may mean Ms. Ortiz needs to come back a second time if it's her situation isn't resolved before then. That's just all I wanted to make plain, is that I'd love to avoid a second trip. And it may be that Ms. Ortiz says, I'm in A-Town, I'm staying the whole week. But that doesn't look like what her face just said. So, but you need to be here today for the call of the calendar. You will manage things going forward, but I'm confident that we will all reconnect before the week is out, so we know what Monday looks like. And Mr. Melnick, also, if Mr. Lloyd's situation doesn't resolve, that will be next up, because I think he's been in jail longer than Mr. Pitts. But I don't foresee Pitts being a trial in the end. We'll see what happens. So just so Mr. Lloyd knows, that's what would go out second.
Judge, I wasn't actually sure when this case was on the trial calendar, but I'm also on that consolidated trial calendar, and I think my case there is older, but I'll double check.
Oh, it is older, and it's number one. I think it's it's interesting. I don't know that it's older, but it's Judge Dunaway's case.
Yes,
Yeah. Is that something you think is going?
I think we're pretty close to getting it resolved.
That's what I heard on the street, which is why I felt that we might be able to get you here.
I don't think I have any other conflicts, but I also don't expect it to be an issue.
Okay, sounds good. Anyone have any questions before I go back and then I'll come out? Yes, Mr. Shapiro. Yes, let's just see if we got that case number. Chat. Yes, I got the case number. So Ms. Pass and Mr. Shapiro, you both are free to go.
Thank you, Judge. Could I ask for that case number also?
Sure. It is 2021 CR 1182. It's in front of Judge Bills, Bills, like Buffalo. And your counterpart would be Aaron, as in Hank, Laga, Laga. That's the prosecutor.
Thank you, Judge.
All right.
Yeah, it's a strange set of facts. And, what is the misdemeanor? That's
Like a lesser, let me see.
because I could always just say, hey, this made sense to me, and just ask for forgiveness later on.
Okay.
Hey, what's going on? Yeah, it's the worst.
What happened?
It's a eye infection, Judge.
Okay,
So it's just,
it wasn't a beatdown from a significant other.
no.
Okay.
I told my wife I was gonna tell you, it was her,
Yeah,
but no, it's just.
things are tough at home.
Yeah, it's just an eye infection. So the doctor said it should go down like within 7 to 10 days,
Okay,
but it looks awful.
it doesn't look great, but otherwise the plaid suit is sharp. It's not super contagious?
It's not, it's just, like when the follicle gets infected,
Mhm.
that's all it is.
Okay,
It's
I'm
not-
sorry, it doesn't look like it's fun.
Not at all, not at all, but I appreciate you having me, Judge.
Sure.
Yes, sir. Yes, sir. So if we don't-
All right, I think I'm ready.
First name, Julie. Check it out, you know, the case number. Off the top, that's-
It's 22 SC 180-415.
Say it one more time.
22 SC 180-415. Using the card.
The felonies, missing, Right. Yeah, as long as
How you doing? I'm ready for Lloyd. Oh, you know what? I got a sweet fish work. Once I had it.
Oh, yes, if you want me to ask this for you, fees be waived, so you can pay for the classes, I can do that. Okay, yeah.
I'm ready to go.
Say one. Come on, basically.
Yeah, so no, all the process.
No,
I don't know where they went. I don't really.
I don't need it. This girl just was there.
We'll say, look, the other she left too. Oh, no, he's not going to. You never know. No, he's not,
You
he's
can,
different.
you can go to the court.
Well, I wouldn't, I wouldn't.
Yeah.
Well, she's not, he's not going to get his kids at 12.
Okay.
I mean, you might be, you might be able, but I just don't even miss
Do
it.
you know this girl's photo?
No. But I also, what do you do?
I thought she was motioning.
Me too, but then she left and went nowhere. Yeah, I don't know. I don't really.
Well, I mean.
Let me know.
I have.
Yeah, like
Horton
common
and
sense.
Lloyd
You know what I mean?
signed up.
Right. And also, like, when she wants my clients. What is that, cell, plea paperwork?
Yeah, this waiver arraignment and entry of appearance.
Which one? I don't understand.
Any idea where your ADA went?
There's 3, but they just leave.
Do you know?
I haven't.
Miss Willingham went next door, Rachel.
Oh, next,
Who am I,
next
is that
door.
God? Is that Miss Nelson?
Yes, it is.
I'm like, where are you?
Yeah, Matt,
She went next door to Judge Lethbridge.
Judge Lethbridge, okay. Thank you.
You want me to reach out to her? You need her?
No. Oh, you can, I guess you can,
Yeah.
if you want to, you can tell her we're waiting for her.
Okay, I'll let her know.
Thank you, wherever you
You're
are. I'm looking up like you're up. I don't know why that's so silly. Like, God, are you up there? Yeah, I actually don't want you guys to talk.
Welcome to order, man. See,
Ms. Wood, you said one of your cases was ready to go? All of your cases are ready to go. Well, why don't you tell me who you want to start with, although let's get Mr. Jordan back in here to see if Brinkley is ready. If Brinkley is not, then we'll do one of yours. Do we have any prosecutors out there?
We'll check next door.
The prosecutors went next door? Okay. Mr. Jordan, are we ready on Ms. Brinkley, or should we, Ms. Wood is ready on all her cases, so we can start with one of her pleas if Mr. Matthews isn't ready to go with Ms. Brinkley.
I believe that we have everything ready to go on Ms. Brinkley.
Do we have Ms. Brinkley and Mr. Matthews?
Just saw them in the hallway.
Okay. What will we do first of your, well, if you've got one with Mr. Jordan, I don't see Ms. Willingham here, so,
Both of mine are with Ms. Willingham.
okay, we will track her down during the course of the Brinkley plea.
Thank you, Judge.
Sure.
Your Honor, they officially extended my stay in the courtroom until June 5th. So,
June 5th.
yes, Your Honor, which was the original date, so.
Okay, wow, excellent. So, and that means Mr. Peoples will stay in Judge Richardson until then. Okay. Mr. Matthews, if you're ready and Ms. Brinkley are ready, if you'll come up to the podium. Ms. Rivers, are you ready?
Yes, I'm ready. Good morning.
Good morning. Happy Monday. This is position 5 on our trial calendar, State versus, is it Quandresha? Quandresha Brinkley, who is represented by Mr. Matthews, who is here in court. Mr. Jordan represents the state. It's 22 SC 180415. Mr. Jordan, if you could let me know which counts you're going forward on and what they will be, if there are any reductions, and then we'll get going.
Yes, Your Honor. The state is only going to proceed forward on count 1, which the state is going to ask to be reduced to disorderly conduct, which is OCGA 16-11-39. And the state will move to dismiss counts 2 through 6.
Okay, so Ms. Brinkley, the state is going to dismiss 5 of the counts that are brought in this indictment, and the one they're not dismissing, they're reducing to a misdemeanor, and that misdemeanor will be disorderly conduct. Is that your understanding?
Yes, sir.
Okay. In a moment, Mr. Jordan's going to put you under oath. Once you're under oath, you'll need to answer a bunch of his questions and mine. If at any point during the conversation the 4 of us are having, you've got any questions, please let Mr. Matthews or me know so we can answer those questions. Will you do that?
Yes, sir.
Excellent. When you're ready, Mr. Jordan.
Thank you.
And can you bend the microphone towards you?
Yes.
Great. Thank you.
Ms. Brinkley, can you raise your right hand, please? Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name for the court, please?
Quandresha Brinkley.
Thank you. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there a medication that you normally take that you have not been given today?
No, sir.
How old are you and how far have you gone in school?
I'm 33 and I went to 11th grade, but I just graduated from adult education last June.
Okay. Are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that you have been charged with 1 count of disorderly conduct?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to this charge? And if you pled not guilty or remain silent, you would receive a jury trial?
Yes, sir.
Have you had enough time to speak with your lawyer, Attorney Matthews, about all of the facts and circumstances known to you regarding the charge in this indictment, including any potential defenses?
Yes, sir.
Do you need any more time to discuss the case with your attorney?
No, sir.
Are you satisfied with his services?
Yes, sir.
Mr. Matthews, do you waive formal reading of the indictment?
So waived.
Do you also waive any and all defects in the indictment, including any with respect to Ms. Brinkley's name?
So waived.
Ms. Brinkley, do you recall having been arrested on this charge?
Yes, sir.
Your Honor, the state is unaware of any outstanding warrants related to this charge. Mr. Matthew, do you know of any outstanding warrants that are related to this charge?
I know of none.
Ms. Brinkley, has your attorney advised to you the minimum and maximum sentence for the charge that you are pleading to?
Yes, sir.
And Your Honor, since this is a misdemeanor, the minimum is 1 day and the maximum is 12 months. Ms. Brinkley, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence? Your Honor, as previously stated, the state is only going to proceed forward on count 1, and the state is asking that the aggravated assault be reduced to disorderly conduct, OCGA 16-11-39. Make sure that's, yes, that's correct. And the recommendation for that count, Your Honor, is 12 months probation. The only special condition of probation is that Ms. Brinkley stay away from the victims listed in this indictment, and I can provide those names during the plea litany. The state also would not be opposed, Your Honor, to probation terminating after the first 6 months if there is no further violations or contact with the victims. Ms. Brinkley, was that the negotiated recommendation that was communicated to you?
Yes, sir.
Do you understand that the court does not have to accept that recommendation?
Yes, sir.
Do you understand that the court can sentence you to the maximum on this charge?
Yes, sir.
Are you currently on probation or parole?
No, sir.
Are you a United States citizen?
Yes, sir.
And my apologies, Mr. Matthews, is Ms. Brinkley asking to use her first offender on this case?
She is not.
Do you understand that you waive any and all defenses, including any mental health defenses, by answering the plea of guilty?
Yes, sir.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, sir.
Do you understand that by pleading guilty, you were giving up the following rights, which I will now list off? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
Ms. Brinkley, how do you plead to the sole charge of disorderly conduct in indictment number 22 SC 180415?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charge against you?
Yes, sir.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that since this is a misdemeanor, you have only 12 months from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, sir.
And do you understand that you only have 30 days from today to file a direct appeal for this case?
Yes, sir.
And Your Honor, for a factual basis, on October 1st of 2021, an officer was dispatched to 340 Thomasville Boulevard Southeast in regard to a dispute with weapons. The caller stated that two families were fighting with weapons. As the officer arrived, he was flagged down by a group of females in a silver Chevy Equinox who stated that they were just hit by a female in a black Dodge Journey. There were 5 people in the silver Chevy Equinox when it was hit. As the officer was talking to the victims to get a story on what happened, they were stating that a female that they knew as the defendant intentionally rammed the vehicle while all 5 people were inside the vehicle and then left the location. The officer spoke to one of the listed victims, Shanquita Jones, and that's Shanquita. Last name Jones has normal spelling, who was the owner of the silver Chevy Equinox and was sitting in the front passenger seat. Ms. Jones stated that they had gone to a club on Old National Highway and were confronted by Ms. Brinkley. Ms. Jones stated that Ms. Brinkley wanted to fight and she didn't know why. Ms. Jones stated that Ms. Brinkley was kicked out of the club by security. Ms. Jones stated that they then went to 340 Thomasville to drop off another listed victim, Ms. Alicia Smith. Both of those names have normal spelling. And that is when the suspect rammed the victim's car. Ms. Jones was complaining of back pain and was transported to the Atlanta Medical Center. The officer also spoke with another victim, Miss Aisha Miller. Aisha is spelled I-E-S-H-I-A. Last name Miller has normal spelling, who stated that the suspect was upset with her because they were both talking to the same male. Miss Miller also stated that the suspect was at 340 Thomasville Boulevard when they got there and started to argue with Miss Alicia Smith in front of her apartment. They all decided to leave the apartments, and as they were backing out, that is when Miss Brinkley intentionally rammed the vehicle. The officer then did speak with everyone else that was on the scene that gave pretty much the same account. That does conclude the factual basis. The other 2 listed victims, Your Honor, are Miss Lisa Robinson, L-I-S-A. Robinson has normal spelling. Also, Miss Sabrina Miller, S-A-B-R-I-N-A. Last name has normal spelling. And I already gave Miss Jones and Miss Miller's information. Your Honor, from speaking to counsel and speaking to the victims in this case, it does seem like there may have been an altercation at the club, and this was just a carry-on of that altercation. I do understand that there is a very different version that Mr. Matthews has on behalf of his client. Just understanding that it was a pretty messy situation and that it may have been a 5-on-1 situation. I do understand the facts of this case. I believe this was something that ADA Hand worked out before he departed the Fulton County District Attorney's Office. I believe this is a fair resolution. Ms. Brinkley also does not have any prior convictions, I believe, especially felony convictions. She may have 1 misdemeanor conviction from before 2017, but she has a very light criminal history. So the state would just ask that you accept this negotiated recommendation, Your Honor.
Okay. The indictment lists Ms. Sabrina Miller as the owner of the Equinox. I don't think that changes anything because you're dismissing that count. You had said it was Ms. Jones. Is there?
Your Honor, from my understanding, that may have been a mix-up. I believe that I was under the impression that Ms. Jones was the owner of the vehicle. And also, as Attorney Matthews will state, Ms. Jones did submit an affidavit that the state has reviewed, stating that she did not want to press charges. So the state would ask that she not be included within the list of stay-away victims, Your Honor.
Shanquita Jones, don't include her.
Yes, Your Honor.
Okay. So one person went to the hospital complaining of back pain, but there was no life flight. No one apparently gravely injured. What about the Equinox? Did Ms. Jones, who I guess is representing to you that she was the owner of the Equinox, did she have to get thousands of dollars of repairs?
No, Your Honor. To be very frank with the court, she was not very responsive to the state. Okay. So we had no request for restitution for the Equinox.
Okay, got it. Good morning, Ms. Jackson. How are you?
Good morning, Your Honor. How are you?
I'm doing well. Can you share with me criminal history for Ms. Brinkley?
Yes, Your Honor. She has 3 cycles
The last arrest was October the 3rd, 2017 with the City of Atlanta Police Department for battery. There was no disposition for that battery, but it appears that it may have been a charge. The charges may have been amended to disorderly conduct in a fray, but they were acquitted on May the 2nd, 2018. There were no convictions listed in the GCIC.
All right, thank you so much. Mr. Matthews.
Yes, Your Honor. Good morning to this honorable court. Your Honor, Quandrisha Brinkley is 33 years old. She has 5 children. She is gainfully employed. She's been working for a number of years with Target Corporation. She is a native Atlantan. And as she stated earlier to the court, she successfully obtained her GED just recently. So she's making strides moving forward, taking care of herself and her children. Your Honor, on this fateful evening, she was entertaining with her other family members at a club here in Fulton County. There was this other group of individual young ladies who saw Ms. Brinkley. And at that club, security removed both parties, both groups. And Ms. Brinkley made her way over to another relative's residence inside of an apartment complex to pick up her children. This group followed Ms. Brinkley to that apartment residence.
This is the Thomasville Boulevard location.
That's right, Judge. And my client went inside the apartment to get her daughter. And when she exited the apartment, she was met. She made her way into her car along with her daughter, but she was met with this group of folks who began to hit on the car on her vehicle, burst her window out. And she was in a complete panic, didn't know exactly how to maneuver and navigate that situation. And she threw her car into drive and she was trying to get out of there. The vehicle may have made some contact with this other vehicle, incidentally trying to get away from the situation, and she drove off. So when the officers arrived, unfortunately, they only had one side of the story, and they were told the officers received that one side of the story, and then that's when the warrant issued forth. Sometime during the course of the investigation and my representation of Ms. Brinkley, I was able to make contact with at least 1 or 2 members of this group who indicated, hey, listen, it was a big misunderstanding. We were partially at fault as well. We recognize that, this had something to do with the guy, and we don't want to see Ms. Brinkley get prosecuted. We want these charges to be dismissed. An affidavit was executed, a notarized affidavit was executed. It was provided to the government. They reviewed it, made contact with the alleged victims in the case. And here we are, Your Honor. We're respectfully asking the court to go along with this negotiated recommendation. We do believe it's reasonable, fair, and the proper resolution for this event. I don't believe that Ms. Brinkley will be before this court under any other circumstances of a new charge or a violation of it or anything of that nature, Your Honor. Thank you.
All right. Ms. Brinkley, how long have you worked at Target?
9 years and 3 months this year.
What do you do now for Target?
I work in the back room. I unload the trucks.
Has that been your job all 9 years and 3 months?
I started on the floor, a sales representative, and I worked my way to the back.
Okay, so it's actually a promotion to be able to get to the back room.
Yeah,
Okay.
kind of.
Are you at a particular Target? Are you at a warehouse?
No, I'm at Target on Edgewood, Caroline Street.
Okay, great. How old is your oldest kid
My oldest child is 18,
and your youngest?
4.
It's a big range. Do they all live at home with you?
Yes, sir.
Okay. Anything you want to add to the discussion we've had?
No, sir.
Did you know any of, I heard a bunch of names and they're all in the indictment, the people who I'll say were in the Equinox. Did you know any of them from
Yes, sir.
before that night?
Mhm.
In what way?
We all grew up in the same neighborhood.
Okay. And then you happened to be at, what was the club you were at?
We was at the Madhouse on Old National.
Okay. And were you there with them, or as Mr. Matthews said, you were there with a group?
I was there with my kid's auntie for her birthday.
Okay. And these other folks were there for whatever event they were having. Okay. And then something happened at the club and you and your kid's auntie and that group got removed?
No, they made everyone leave.
The whole club? They emptied the whole
Well,
club?
I mean, their party and our
Right.
party.
That's what I was getting to. So your group had to leave, as did the other group, because of some
Words was it changed?
words were exchanged. Okay. All right. And then at Thomasville, the 340 Thomasville Boulevard, you were going there to pick up one of your kids?
Yes, my oldest daughter.
Okay. All right. Do you have any questions about anything we discussed?
No, sir.
All right. Well, Ms. Brinkley, I find that there's a factual basis for your plea. That simply means that it sounds like the state could prove disorderly conduct based on what happened that night. I also find that your plea is knowing and voluntary. Voluntary means that no one is forcing you to enter this plea, but you've decided after consulting with your lawyer and maybe others that this is the best way forward for you. Is that correct?
Yes, sir.
And a knowing plea is simply one where you've understood anything. Do you have any questions about anything anyone has said?
No, sir, not at the moment.
Then I will accept your plea. Do you, Ms. Brinkley, authorize my staff to sign the indictment indicating your plea to count 1, which has been reduced to disorderly conduct?
Yes, sir.
Mr. Matthews, can we sign for you?
Yes, Your Honor.
And Mr. Jordan?
Yes, Your Honor.
All right. Ms. Brinkley, I am going to sentence you to 6 months probation. The special condition of your probation is that you will have no contact with Aisha Miller,
Yes, sir.
Sabrina Miller,
Yes, sir.
Alicia Miller. Are they all sisters?
No, Alicia's, no, her last name is Smith.
Okay. It says Alicia Miller in the indictment. Is it actually Alicia Smith?
Yes, sir.
Okay. So Alicia Smith, Sabrina Miller, Aisha Miller, and Lisa Robinson.
Yes, sir.
Those 4 folks for the next 6 months. If you walk into Madhouse and they're there, you have to walk out of Madhouse.
Yes, sir.
You don't need the bouncer to tell you to leave. That's just, they're going to be there and you'll have to come back there another night. And not just Madhouse, anywhere. You just, if you know where they live, stay away from their space.
Yes, sir.
And go about your business. It sounds like Ms. Jones doesn't have the same request, so you can be around her if that's something that happens, or at least if you end up in the same spot, you don't have to leave just because she's there. Okay?
Yes, sir.
Anything else, Mr. Matthews, on behalf of your client?
No, Your Honor. Thank you.
Mr. Jordan?
No, Your Honor.
Okay. Ms. Nelson, should Ms. Brinkley stay here this morning to meet with misdemeanor probation?
Yes, sir.
Okay. So Ms. Brinkley, Mr. Matthews will probably give you some parting instructions. He may need to go elsewhere in the building,
Yes, sir.
but I'm gonna have you stay here. Deputy Gordon knows the folks from misdemeanor probation. So when they show up, they're just gonna get contact information from you and maybe give you some contact information so that you can have get introduced to misdemeanor probation session sometime soon. Okay?
Thank you so much, Judge.
All right. Thank you, the 3 of you.
Thank you so much, Your Honor. Pleasure to see the court.
Good luck with things.
Thank you, Judge.
All right. All right, we don't have Ms. Willingham, so your cases are all with Ms. Willingham. She's next door taking a plea. She'll be back. So we can do Mr. Lloyd if that's ready. And then if Ms. Feely, you've got any cases with Mr. Jordan, we'll do those after that.
Sure. And as they're coming up, yeah, position 11, Tiana Smith. I did go over the specifics of the diversion offer and she is interested in doing that. So I kept her here just so the court could release her, but she is going to do that.
Great. Ms. Smith? Hey there. So you understand what the requirements are for pretrial diversion? Great. Well, you'll get a copy of the order that I sign that says your case is basically being put on hold. And while it's on hold, you'll have time to take care of all those obligations. Assuming you do that, the state will be required to dismiss your case. If for some reason you don't do the things that you said you're going to do, then the state can bring the case back and then we'll just put you on a trial calendar again. But my guess is you'll do what you said you're going to do. And you don't need to come back to court for that. I'll just get an update from the prosecutor and your lawyer that you took care of all those obligations, and then I'll sign something that dismisses the case, okay? Any questions? That's a good question. How does Ms. Smith plug in with pretrial diversion? Will she be contacted?
Yes, I believe that Ms. Feely may have the information, but they'll give her a start date, and then she'll report for the start date, and they'll give her everything that she needs.
So there's some orientation or kickoff meeting that Ms. Smith will go to.
Yes.
Okay, so you should get information from the district attorney's office, but if it's been a couple weeks and you haven't heard anything, reach out to Ms. Feely and she'll figure out what the situation is, okay? All right, thank you. You too. So you've been since December 29th of 2021. Does that sound right? Ms. Rivers, you ready for another plea?
Yes, I am.
Okay, this is position one, the only position on our supplemental trial calendar. State versus Lloyd, 22 SC 181130. Mr. Lloyd is here. Good morning, sir.
Good morning, Mr. McBurney.
I haven't seen you in person in a while. I've seen you on a screen a bunch of times, but welcome back to 8D. Mr. Lloyd is here with his lawyer, Mr. Melnick. Mr. Jordan is the prosecutor. Mr. Lloyd, Mr. Melnick told me that you are prepared to enter a plea. It's what we call a non-negotiated plea. So Mr. Jordan is going to make a recommendation that is different and presumably higher than what Mr. Melnick is going to recommend. And then Mr. Melnick said something intriguing to me this morning before you came out, saying that this is a plea with a cap. So I'm gonna have him explain what he thinks he means by that, and then I'll let you know how it's actually gonna work. And it may be exactly what Mr. Melnick said, but if it's something different, I wanna give the two of you, you and your lawyer, a chance to talk about it, so you can decide if you still wanna go forward with the plea, okay? So Mr. Melnick, tell me what you were thinking when you said, hey, it's a plea with a cap.
So basically the state has agreed that they'll ask for a sentence of 10 to serve 5. And that would be the highest as far as prison time, that would be the highest that could be imposed in this case.
Okay. So it's a cap on me as well.
Well,
that's the thinking.
So, I mean, I guess I don't do these a lot in Fulton County, but I see them done, and I've done them several times in other counties. I mean, theoretically, of course, obviously, you could impose any sentence that you deem appropriate, given that this is a non-negotiated plea. But
Right.
the understanding is that the state's recommendation would be the highest level of imprisonment that could be imposed in this case, and I will be asking for something less.
Okay. So Mr. Lloyd, let me tell you how it's going to work from my perspective. It sounds like you know what the state's going to recommend, 10 serve 5. You'll get credit for all the time you've been in. These are parolable offenses. You're not seeking a recidivist punishment.
No, there is no recidivism in
Okay,
this case.
not even possible. So that's what the state's going to recommend. Mr. Melnick, I'm sure already told you what he'll be arguing for. The lowest it could be would be time served, which would get you out ASAP. It may be higher than that, but certainly less than 5 years. I'm not bound by any of that. And so it's possible that I could give you more than 5 years. This cap is I think it's some signaling from the lawyers, but I want you to understand if you want to go forward with this plea. I'm going to hear what Mr. Jordan has to say about the case, which is the state's perspective. I will hear from Mr. Melnick, and maybe even you. You may have things you want to say because you have a right to give your perspective after Mr. Melnick has said what he's going to say on your behalf. But I need you to understand that I could hear things that make me think, you know what? I'm making this up. The victim's eyeball got shot out. And that's not 5 years. I'm not comfortable doing that. And I might say 6 years or 7. And the way you're charged here, aggravated assault, that's 1 to 20. I'll give you 20 years. I don't share that with you because I typically hand out 20 years. I don't. I'm typically very much influenced by what the two sides have to say, because you know who knows a whole lot more about the case than me? The lawyers. And they probably know an extra whole lot about this case because your case has been rattling around for a while. So even though there have been several prosecutors, I suspect Mr. Jordan has a pretty good feel for what the case is about. He better, because it's on a trial calendar. But I don't want you to think that I would be precluded from giving you 6 years if I think that that's the right thing. I understand that there's this recommended cap, but that's not something that can bind me. There may be judges in Georgia who say, all right, I'll roll with that. But I'm not one of them. I need to impose the sentence that I think is reasonable and proper in light of all the things I learned from the prosecutor, from Mr. Melnick, and then if you have something to share from you. So your sentence may well be somewhere in between what Mr. Melnick asked for and what the prosecutor asked for. It probably won't be less than what Mr. Melnick asked for. It probably won't be more than what Mr. Jordan is asking for, but it could go in either direction. I could give you less than what Mr. Melnick asked for if I conclude from all this that this is much ado about nothing. I'm guessing that won't be how it plays out given the state's recommendation, but I also might see it as the state is seeking to over penalize you for what happened. I don't know. I can't know that yet because I haven't heard about the case. So you've been nodding your head, but I need to have you tell me if you understand what I've just said and if that causes you to want to have some time to talk with Mr. Melnick or if you're okay going forward.
I'm okay going forward.
Okay. Mr. Melnick, is there anything more you want to get on the record after the exchange that Mr. Lloyd and I had?
No, Your Honor, we're ready to proceed.
Okay. Mr. Lloyd, in just a moment, Mr. Jordan's going to put you under oath. Once you're under oath, you'll need to answer his questions and mine truthfully. While you are answering these questions, if you've got questions of your own because someone says something that's confusing or it's not going the way you thought it was going, I need you to let Mr. Melnick know, tap him, say, wait a minute, or let me know, and we'll do our best to answer your question. Will you do that?
Yes, sir.
Great. And when you are answering questions, make sure you speak up. You have a soft-spoken voice. The court reporter needs to be able to hear your answers so she can make a good record of our conversation. All right?
Okay, yes, Your Honor.
Great. Okay, Mr. Jordan.
And Your Honor, before we begin with the plea litany, the state did want to remark that the state is moving to dismiss count 3 as a part of this non-negotiated plea, which is possession of firearm by a convicted felon. Mr. Lloyd is not a convicted felon as of the beginning of this plea litany. He had used his first offender on 12 SC 112339 and had actually completed his first offender months prior to this incident. So count 3 was charged in error. He at the time he was not a convicted felon.
Can you give me that 12 SC number again, please?
Yes, 12 SC 112339.
Thank you.
And Mr. Lloyd, can you please raise your right hand? Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name for the court, please?
Sanchez Deontay Lloyd.
Thank you. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there a medication that you normally take that you have not been given today?
I take risperidone.
Okay, and what is that for?
It's for mental health.
Okay, and do you know, is that prescribed?
Yes.
What is the dosage that you normally take?
5 milligrams.
Okay, and does it have any effect on your ability to understand this proceeding?
No, sir.
Your Honor, did you want any further questions?
I do. So, Mr. Lloyd, when's the last time you took risperidone?
It was this morning before we got here.
Okay, so you got today's dose.
Yes.
When you take that medicine, does it make you woozy or drowsy or anything like that?
No, it makes me calm.
Okay, so you're feeling.
It makes my mind stop racing.
Okay, so right now you're feeling calm and there's not too much mind racing?
Yes, right.
Okay. Have you been regularly getting the risperidone while you've been in jail?
Yes.
Good. Okay. Well, if at any time you're not feeling calm, please let me or Mr. Melnick know. All right?
Yes. Okay.
Thanks.
Mr. Lloyd, how old are you and how far have you gone in school?
I'm 35 and I have a high school diploma.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have been charged with the offenses of aggravated assault, possession of firearm during commission of a felony, and 2 counts of misdemeanor battery?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you pled not guilty or remain silent, you would receive a jury trial?
Yes.
Have you had enough time to speak with your lawyer, Mr. Jonathan Melnick, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss the case with your attorney?
No.
Are you satisfied with his services?
Yes.
Mr. Melnick, do you waive formal reading of the indictment?
We do.
Do you also waive any and all defects in the indictment, including any with respect to Mr. Lloyd's name?
Yes, we do.
Mr. Lloyd, do you recall having been arrested on these charges?
Yes.
Your Honor, the state is unaware of any outstanding warrants related to these charges. Mr. Melnick, do you know of any outstanding warrants that are related to these charges?
No, I'm not aware of any outstanding warrants.
And Mr. Lloyd, has your attorney advised you the minimum and maximum sentence for each charge that you were pleading to today?
Yes.
And Your Honor, just for the record, for count 1, aggravated assault, the minimum is 1 year and the maximum is 20 years. For count 2, possession of firearm during commission of a felony, that is 5 years consecutive. And for counts 4 and 5, since those are misdemeanors, the minimum is 1 day and the maximum is 12 months. Mr. Lloyd, do you understand that this is a non-negotiated plea and the state may still recommend a sentence to the court?
Yes.
Are you aware of the state's most recent offer?
Yes.
And Your Honor, just for the record, as Attorney Melnick stated before the plea litany, the state's most recent offer was 10 to serve 5, with the balance being probated. The only special conditions of probation would be that Mr. Lloyd not have any contact with the victim, Miss Taisha Jackson, and that's spelled Tyisha. Last name Jackson has normal spelling. Did you discuss this offer with your attorney?
Yes.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
Yes.
Do you understand that if you enter a non-negotiated plea, my apologies, Your Honor, since he is past the final plea, would you allow Mr. Lloyd to withdraw?
No, that's why we had the discussion we had at the beginning of this conversation.
Understood. Mr. Lloyd, do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes.
Are you currently on probation or parole?
No.
Do you understand that since you're being placed on probation as part of the state's recommendation, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes.
Do you understand that your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, and your ability to obtain employment?
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes. Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Can you say again?
Sure. Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Okay. Yes.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you were giving up the following rights, which I will now list off: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Mr. Lloyd, how do you plead to the charges of aggravated assault, possession of firearm during commission of a felony, and 2 counts of misdemeanor battery in indictment number 22 SC 181130?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that for the felony charges, you have only 4 years from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
And for the misdemeanor charges, you have 12 months from today to file that same petition?
Yes.
And do you understand that you only have 30 days from today to file a direct appeal?
Yes.
And Your Honor, for a factual basis, on Wednesday, December 29th of 2021, an officer from the Atlanta Police Department was dispatched to 1033 Hollywood Road, which is within Fulton County, in response to a fight call. While en route to the call, dispatch advised that a female caller stated that a Black male had assaulted her and that she was actively hiding inside of the leasing office. The remarks on the 911 call stated that the suspect was a light-skinned Black male with a burgundy shirt, black pants, and dreadlocks. When the officer arrived, he observed a male standing in front of the leasing office. The male, later identified as Sanchez Lloyd, was wearing the same burgundy shirt that was listed. Mr. Lloyd was then detained. A Black handgun was recovered from the left pants pocket of Mr. Lloyd. Mr. Lloyd was read his Miranda rights. At that time, he said that he did not want to speak with the officer, but he later did make statements while he was in the back of Officer Cadogan, and that's Cadogan's vehicle. Upon entering into the leasing office, the officer observed the victim, Ms. Taisha Jackson. Ms. Jackson had a visibly swollen right eye. The victim's right eye was swollen shut and could not be opened. The victim advised that she called 911 and stated that the incident occurred at 177 Maury, Moury Avenue Southwest at approximately 4 o'clock that morning. Ms. Jackson stated that the suspect woke her up at that same time because he was upset after he went through her phone and saw that she had sent photos to another male via Facebook. Ms. Jackson stated that the suspect then pointed a Black handgun at her head and stated, "Bitch, get up, I'll blow your brains out." The victim stated that she responded by asking what he was talking about. Ms. Jackson stated that the defendant then showed her that he had been looking in her phone. While she was looking at the picture, the victim stated that the suspect punched her in her right eye. As a result of being struck in the eye, the victim stated that her eye was completely swollen. The victim stated that she responded by fighting the accused. During the fight, the victim stated that the defendant headbutted her in her eye, causing her eye to bleed. The victim advised that they continued to fight until the defendant's brother asked both parties to stop fighting. At that time, the victim advised that the accused's brother asked her not to call the police. Ms. Jackson advised that the accused eventually calmed down after a few hours. She stated that she had convinced her to take her back to the apartment complex so that she could renew her lease before she was evicted. When they arrived at the leasing office, the victim stated that she told the property manager and then called 911. She did advise that they had an on again and off again relationship and that they did not share any children together. The victim stated that Mr. Lloyd was, retract that part, Your Honor. Your Honor, I did have the opportunity to speak with Ms. Jackson at length in regards to this case. She has stated, she has provided a victim impact statement, which I can now read into the record.
So you were going in some direction and you paused. Is it, and Mr. Melnick can clear this up if there's some question. Ms. Jackson and Mr. Lloyd's connection was romantic. At some point they were involved,
Yes, Your Honor.
but they don't share any kids.
That's correct.
And so if there's a no contact, that's not going to be complicated by the fact that, well, Mr. Lloyd has a right to see his son. They don't share kids.
They do not need to see one another at all.
Okay,
Correct, Your Honor.
makes it easier.
Yes, Your Honor. And this is a victim impact statement by Ms. Taisha Jackson. And she does go through a lot of the facts again, Your Honor. So I apologize for what may be redundant.
She's got a right to be heard, so it'll come from you.
On December 27th of 2021, myself, Taisha Jackson, and Sanchez Lloyd were at a family member of his residence off of University and Pryor. The complex is Carver Homes, where we engaged in company with one another after hours. Our time together surpassed. Mr. Lloyd had went through my phone and he had seen a picture of myself that was provocative. He then began to punch and hit me. That's when I was awakened. He was very upset and angry and violent and continued to scream and yell and hit me. Then he had a gun in his hand and proceeded to point it at me and hit me and threatened me with the gun. I found a way to calm Mr. Lloyd down. I believed after he saw the injuries that he inflicted upon me, hours passed by, and I convinced Mr. Lloyd to bring me to my residence, which is located at 1033 Hollywood Road, Northwest Atlanta. Mr. Lloyd waited outside of my rental property with a gun and a white Dodge Stratus, which is his mother's car. My landlord, Miss Serena Wells, then called Atlanta Police Department, and shortly thereafter they arrived. Mr. Lloyd was on the phone while he was located outside of my residence, and that is what kept him on the property until the police came. When the officers arrived, they had seen the injuries that Mr. Lloyd afflicted upon me and questioned me, and then arrested Mr. Lloyd. I pled with the court to not release Mr. Lloyd because he is very violent and narcissistic and has threatened to kill and harm me and my family for the consequences that he faces today. I'm looking for assistance with relocating because the arrest happened where I reside. And I'm afraid of Mr. Lloyd's release to come back and retaliate. So I beg the court for assistance in relocating me and my family for Mr. Lloyd to not be released for what he has done. I'm very thankful that I was able to survive such an attack. And I am in counseling for PTSD for the damages it's caused me physically and mentally. It's caused me physically, mentally abuse is exactly what she has in the victim impact statement. Your Honor, I did have, as in preparing for this trial, I had a deep knowledge of this case, and I did review the body cam footage. When the officers do arrive, Mr. Lloyd immediately says that I know that I'm going to jail for aggravated assault. He does make statements in the back of the police car of Officer Cadogan, in which he states that people are going to see her face and wonder why I did this. It's because that she's on drugs. And Ms. Jackson did confirm to me that she was a cocaine user at the time of this incident, but that she has since become clean. Your Honor, there were the reason for the state's recommendation, given that Mr. Lloyd is not a convicted felon at this point, is that Ms. Jackson's face was heavily swollen. The statements that Mr. Lloyd made outside in the police car showed no remorse of the situation. They had a prior difficulty in which the state filed that prior difficulties notice, in which Mr. Lloyd attacked Ms. Jackson in a public place and had to be tased in order to pulled off of Ms. Jackson in front of a police officer. So these two did have a history together. So the state is asking for the 10 to serve 5, and I can give Your Honor a breakdown if you would like to of the sentence. But that is the reason why the state is asking for this particular recommendation, despite Mr. Lloyd not having any felony convictions.
Okay. Did Ms. Jackson have lasting damage to her eye, or it has recovered?
It has recovered, yeah.
Okay. And has your office attempted to connect Ms. Jackson with resources? I know part of her comments to me were put me in witness protection, something to that effect. Of course, the courts have no ability to do that, but there are resources available for victims of crime. Has she been connected with that support network?
She has, Your Honor. My victim advocate, Ms. I don't want to butcher her name, but it's Dianelli, D-A-I-N-E-L-L-Y, did get in contact with Ms. Jackson. I do believe that they have gotten her in contact with the proper parties as far as relocating, getting new furniture, and being able to move from her current residence.
Okay, got it. Thank you. Ms. Jackson, can you tell me the criminal history information you have for Mr. Lloyd, please?
Yes, Your Honor. The defendant has 13 cycles. The defendant's last arrest was February the 8th, 2021, with the City of Atlanta Police Department for 2 counts of terroristic threats act and simple battery. I did see, well, one of the terroristic threats acts were null pros on July the 30th, 2021, but there was no disposition for the other charges. Also, the defendant received first offender treatment in 2013 for robbery and burglary. That case was sealed February 26, 2020. Nothing in addition, Your Honor.
Thank you. Good morning, Ms. Tucson. Do you have any active probation for Mr. Lloyd?
No, Judge, just the previous one, Ms. Jackson mentioned, that's now inactive, the first offender, the 12 SC.
Yep. Okay. Thank you.
Okay.
Mr. Melnick.
Thank you, Judge. Good morning.
Good morning.
Your Honor, Mr. Lloyd is 35 years of age. He is accompanied in court by his mother, Kathy Holliday, who's been very actively involved in helping me and supporting Mr. Lloyd in this, what he's been going through.
You should know, Mr. Lloyd, you probably do, but your mother comes to court even on days when you're not going to be here, just because maybe the messaging system isn't quite accurate. But I've seen your mom more than almost some of these lawyers who are here routinely. So she is very serious in her commitment to supporting you. I hope that that's something you rely on, but don't take advantage of when you do get out.
Judge, so Mr. Lloyd has had some very difficult circumstances in his life. His father was murdered when he was relatively young. As it didn't, the impact of that didn't occur immediately, but as he got older, Ms. Holliday has told me that his mental health condition has deteriorated to the point where he was diagnosed as being bipolar, severely bipolar. And he was actually declared totally disabled as a result of that and post-traumatic stress disorder. And I had forwarded to Mr. Peoples and to Ms. Nelson a Social Security Disability Award letter that was given to Mr. Lloyd not too long before he was arrested on these charges in May of 2021. They were still grappling at that time with how best to deal with Mr. Lloyd's mental health condition. I am encouraged. It's one of the few times that I've ever heard of somebody actually getting the mental health treatment in jail that they actually need. And I can tell you that in my interaction with Mr. Lloyd, the behaviors and characteristics that have been described in this case have not been evident at all. I think that as long as he is able to maintain a treatment plan, that he will not have the types of situations that have caused him to serve the last 17 months or so in jail. He's been in continuous custody since December the 29th of 2021. No medical records were ever produced for me in this case, Judge. So I don't believe that there was any sort of, I'm not aware of any treatment having been sought. And so from the standpoint of what injuries were incurred, it appears to have just been swelling to the face, which I'm not saying is a good thing, but at least it was not more severe than that. And I know that Ms. Jackson has been very vocal concerning her feelings about Mr. Lloyd. All I can say is that this is just not the kind of case where somebody spends the rest of their life in jail. And it's just with his record and with the facts and circumstances of the case, I think that the sentence that the state is recommending, that the state is asking for, is unduly harsh. The most egregious thing, in my opinion, actually is the battery part of this case. And Mr. Lloyd has already done all
more than 12 months.
More than 12 months. And he was not a convicted felon at the time. I neglected to mention, Judge, he also is accompanied in court today by his sister, who has a child that Mr. Lloyd has never seen, had that child since Mr. Lloyd has been in custody, as well as his aunt, who's very close to him and close to his family. And all of these people have told me that upon his release, they will be there for Mr. Lloyd to ensure that he, number one, does everything that he's supposed to do with regard to his mental health treatment. Ms. Holliday has provided me with the name of his doctor located in Midtown, and she's already, making arrangements for him to go into treatment. And he has spent a long time in jail, Judge. 17 months in jail is a very long time. I am very sorry about Ms. Jackson, and I don't want to undermine the seriousness of what happened in this case, but for all intents and purposes, this is Mr. Lloyd's first offense of this nature. And normally a sentence this harsh would not be imposed. I believe that a big reason why the state is asking for this sentence is because of Ms. Jackson's vocal opposition to Mr. Lloyd being released from custody. Judge, I wasn't sure. Ms. Holliday, did you want to address the court at all? Yeah.
While she's coming up, what can you tell me, Mr. Melnick, about the terroristic threats arrest? That would have been the same year as this situation, or much earlier in the year, but is it still rattling around out there?
No. It looks like it was dismissed, except for a simple assault charge that was reduced to 22 days time served.
Okay.
And that was not a violation of his probation.
Okay. So Ms. Holliday, if you'll just get near that microphone right there between the two lawyers. Great. Thank you.
Good morning, Your Honor.
Good morning.
I don't know if it's still morning or not. Anyway, I'd like to say, yes, my son went through a lot. He's coming home. He needs to come home. When he lost his father in a crossfire. His father. I didn't know it was bothering him. I didn't know. It built up in him. But he still maintained he was so an honor roll student. All three of my kids on the honor roll. He made so many A's. I was giving him $20 for each A. He made so many A's, I had to break it down to $5 an A. $5. I said, wait, I can't keep it for and giving him. But on that, he's good. He made, I don't want to say he made a mistake or whatever, but his father, I know he goes and visits the gravesite. He's not crazy, he missed him. He said, God took away his hero. God took his hero. I said, but I'm here. I'm still
How
here for
old
you.
was your son when
His father was
killed?
Sanchez was probably about 12 or 13. And my daughter back then, she was 9. She was 9, and no one was never arrested. No one was never charged for it because the bullet exploded his head. But I didn't know it was bothering my son. But he still maintained to make good grades, coaches, and everybody. He had so many certificates. I shared with Attorney Melnick, like 20 pages. He's not an average criminal or thug or nothing. He was, he got lost, but he can come back. You can bounce back. He gonna bounce, but he's not a bad person. And that Aisha Jackson woman, she has busted my car windows. He is too. She would lie and say that She would be in the back of the store with the store owners having sex to make him jealous. She would call me in the middle of the night. She said, "You'll never see your son again. I bet you won't." By him being incarcerated. She said, "You'll never see him again. I promise you won't." Like she's doing
Sounds
it on
like
purpose.
they didn't have a real healthy relationship.
He was trying to leave her alone. She kept calling him. She was jealous about the other young lady he had that died, Ashante Scott. She said, he's still in love with a dead BITCA. That's what she said. He in love because he would keep her picture in his car, in his dead picture. And when Taisha would ride in the car, she took the picture down and wanted to rip it up. So he's still in love with her. She's mad right now because he don't want her. I know. She calls me on crack cocaine in the middle of the night and telling me that you'll never see him. And she laughed and hangs up. Last time I came to court, I heard her voice. She got another guy here, the same thing. She has another guy here saying, they shouldn't have put a hand, whatever happened to the case, but she do things on purpose. I was told by a man said she's known for taking men off the street. That means taking away their life, to put them away, incarcerate them. A guy told me, the man told me, he said, she's known to tell your son to please stay away from around her.
Well, that'll be what happens here. Mr. Lloyd won't be around Miss Jackson anymore.
He don't want to be.
Okay, well, good. Well, Ms. Holliday, I want to thank you for your support of your son. We too often see young men come into court and there's no one, there's no family. And that explains a lot of why they're in the problems they find themselves in, because they don't have a support network. But he's got a sister, he's got a mother, and hopefully when he gets out, he will make them proud and stay on his medication and stay away from folks like Ms. Jackson.
And I promise he'll never be in your court again, Your Honor.
Well, he's welcome to
He may
visit.
see you in Walmart, but he'll never see you in
There
here.
you go. All right. Thank you, Ms. Holliday.
Thank you.
Mr. Melnick, anything else?
No, Judge. I don't know if you're ready for me to say what I was going to be.
I want to hear that, and then I'll need to hear if Mr. Lloyd has anything he wants to add.
Judge, so what I'm asking you to impose is a sentence of 10 to serve 2 and reduce that to the time that he has served and put him on an ankle monitor for the next 6 months with 24-hour GPS monitoring and make it a condition, obviously, that he have no contact with Ms. Jackson and that he continue or undergo any mental health treatment that is recommended by whatever professional he is seeing.
That last point, I want to make sure I incorporate into the sentence, because the kind of blunt instrument I have is mental health evaluation, follow any recommended treatment. I don't mean to require that Mr. Lloyd go through another battery of tests if there's already a medical provider familiar with Mr. Lloyd, but that will be a relationship that is necessarily out of date because Mr. Lloyd's been in jail for almost 500 days. And so it seems that maybe the evaluation makes sense because he'll be meeting with a new doctor. But I'm mostly interested in that continuity of care. Whatever he's getting right now seems to be helping a whole lot. And whether the physician on the outside says it'll be something slightly different, it's that medication that is going to allow Mr. Lloyd to not come back here.
I believe so as well.
So I think the way I'll structure it is mental health evaluation with any recommended treatment. But if there's a particular doctor who would be able to see him and there'd be coverage for that treatment, I can include that in there. I'm just usually reluctant to say, you got to see Dr. Smith.
Sure.
Maybe Dr. Smith says, I'm not taking new patients anymore. Okay. All right. Mr. Lloyd, is there anything you want to add beyond what I've heard from Mr. Melnick, who has been working very hard on your behalf for many, many, many months, or what I've heard from your mother?
I just want to say I'm sorry for everything that happened. And I want to thank you for letting me see my angel, my mama, and my sister and everybody. I ain't never been away with my mama here long, ever. I just want to get back my treatment and everything. I was doing so good, Mr. McBurney. I was doing so good. And I just missed her. But I'm in here though. That's all I got to say, Mr. McBurney. I miss her so much, man.
Well, thank you, Mr. Lloyd, for sharing that. You have been away from your family for a long time, not without reason. I heard a lot about Ms. Jackson, but she's not the villain in this situation. She didn't punch herself in the eye. And that's sort of what we're working through here. All right, let me say the things I need to say. First, Mr. Lloyd, I find that there's a factual basis for the plea. And all that means is that if we did go to trial and the state was able to prove all the things that Mr. Jordan talked about, where they're corroborating witnesses like Ms. Wells, the leasing manager, and the things you said to law enforcement, I think a jury could find you guilty. I don't know that they would. You've got a good lawyer. There are some defenses here, but they could, and that's what I need to find. I also find that your plea is voluntary. That means no one's forcing you to go forward with this. It's something that you've decided after much thought and maybe consultation with your family and certainly consultation with Mr. Melnick, but this is what you want to do. Is that correct?
Yes.
Okay. I also find that your plea is knowing, meaning you've understood the things we've talked about. And when you didn't, I watched you do it, you'd ask a question of Mr. Melnick or of me. Do you have any questions at this time?
No.
Okay. I'm sentencing you pursuant to the Probation Options Management Act. And all that means, Mr. Lloyd, is that while you're on probation, which you will be for a while, if you have any minor violations, you and probation will sort through that. But if it's a more significant violation, you get arrested again, or you violate one of the special conditions, I'm going to tell you what those are in a minute, that comes back to me. Mr. Lloyd, do you authorize my staff to sign the indictment for you indicating your guilty plea?
Yes.
Mr. Melnick?
Yes, Judge.
And Mr. Jordan?
Yes, Your Honor, and I do have the plea of guilty.
Oh, great. I will take that. Mr. Lloyd, I have in my hands a form labeled plea of guilty, and it's got your initials next to a whole bunch of different sentences. Did Mr. Melnick walk you through this document?
Yes.
And answer any questions you had?
Yes.
Is this your signature here on page 4?
Yes.
Okay, Mr. Melnick, you signed it on page 5?
I did, yes.
Great, I'll make that part of the record. So, Mr. Lloyd, I am going to sentence you as follows. Let me get to your sheet here. On count 1, which is aggravated assault, I am sentencing you to 3 years to serve 2 years with the balance on probation. So that's 1 year probation there. You will get credit for the 496 days you've been in custody. Count 2 has to be 5 years, has to run consecutive. So that'll be 5 years. I'll probate those. 3 has been dismissed. 4 and 5 are misdemeanors. They will both be 12 months to serve. They will run concurrently with count 1. So it is a total sentence of 8 years to serve 2 years with a balance on probation. And you'll get credit for time served. Special condition number 1, the most important condition of your probation is leave Ms. Jackson alone. Don't call her, don't write her, don't text her. If she's got some social media page, don't put something on there saying, I'm sorry, or I'm going to get you. And your family needs to do the same. If Mr. Jordan is back here in court with you and Mr. Melnick, and he's showing me social media and your mom's blowing it up saying, I can't believe you did this to Sanchez, that's going to be your problem and not your mom's. You will go to jail. So you need to make sure that Ms. Jackson goes in her direction and you and your family go in your direction. Now, it's not a trap. If Ms. Jackson starts texting you, do not write back to her, but you get that to Mr. Melnick and he'll get it to the prosecutor and I'll have a conversation with Ms. Jackson. But if she reaches out to you, don't respond. Don't write her back. Because if you write back, there's contact. And it sounds like she's going to go straight to the prosecutor and I'm going to need to do something about that. So that's a chapter that is closed. Forget about it. I mean, you're never going to forget about being in jail for a long time, but don't bother Ms. Jackson about anything. And that goes for your family as well. Special condition number 2 is that I'm going to require that when you are released, you submit to a mental health evaluation. And that is not for us to learn something new. Your mom has made it real clear. Your lawyer's made it real clear. You're working through PTSD, maybe some bipolarity, and taking something like risperidone helps you stay calm, stops your mind from racing. And when you're calm and your mind's not racing, you're not going to pull out a gun and point it at someone. You're not going to bust someone in the eye. And that's how you need to have it work going forward. So you can be there for your sister and her little kid that you haven't even seen yet. But that is that a boy or a girl? A girl. So your niece needs her uncle around, and you're not going to be around if you're not taking your medication and you're out there doing things like what happened with Ms. Jackson. Okay. And the last condition, special condition of your probation is that if you are prescribed any medication, you must take that medication. So it's not optional. It's like, I don't feel like taking it. Now, if the medication makes you feel bad, you talk to the doctor, and the doctor gives you a different medication. But you don't play doctor and say, I don't like this stuff, I'm not going to take it. If I get a report back from probation that Mr. Lloyd's just not taking his medication, we're going to have a conversation really for your safety, because when you're not on a medication, if you're doing things like this, it may be next time when your mind is racing and you're not feeling calm and you happen to be near a weapon and you reach for that weapon, someone else reaches for a weapon and it ends in a real bad way. So this mental health treatment is meant to help you be there for your mom and your sister and the other people in your life. Mr. Jordan, do you have any other conditions you want to see in Mr. Lloyd's case?
No, Your Honor.
Mr. Melnick, anything else on behalf of Mr. Lloyd?
No, Your Honor. Thank you.
Okay, I appreciate everyone's work on this case. I know it has taken a while to reach this point. I think this is a reasonable sentence, a little bit more than what Mr. Melnick asked for, but I think it reflects the risk that was involved. I appreciate the fact that Ms. Jackson wasn't seriously injured, but the potential was there for it to be a whole lot worse. And hopefully this is a one-time situation for you, Mr. Lloyd. You're young, but you're not a young man anymore, and you need to be making different decisions going forward. I think the medication can help you make those better decisions. Okay. All right. Ms. Tucson, do you need to give Mr. Lloyd any reporting instructions, or he'll get that when he is released?
I would just like to have if I could put an address on file and phone number, maybe
Sure.
for wherever he will reside when he is released.
Is it your address?
340, yeah.
Just say it again.
340 Lee Street.
340 Lee Street, and that's Atlanta, correct?
Forest Park, Georgia.
Forest Park. 340 Lee Street, Forest Park, Georgia.
0297.
Did you hear that?
Why don't you say?
340 Lee Street,
Yeah,
Forest Park.
30297.
Is that Clayton County or Fulton County?
Clayton County.
So that's Clayton County.
Okay, yes, the probation office is in Morrow, so they'll give you the instructions. Your docket will already be placed in the system. Is there a phone number that I can put on file for one of your family members?
404 604 4622 4622.
404 604 4622.
That's correct.
Okay,
And
thank
that's
you.
Kathy Holiday with one L. His mother.
Okay.
All right.
Thank you, Judge.
That's it. Thank you.
Judge, do you use your arraignment calendar tomorrow on Zoom? Or is
It's a bond arraignment calendar. There will be a Zoom link, so you are welcome to plug in virtually. All right. You have a second case on the consolidated Satterwhite with Judge Eaton.
Oh, yeah. So that's an unusual situation. I don't think that one's gonna go.
Okay.
The primary defendant in that case,
There are two Satterwhites and another person.
male Satterwhite, who's not for the life of me remember his first name. He's the one who's charged with murder. My client is only charged with hindering the apprehension. I think misdemeanor obstruction. The attorney for the murder defendant said he probably isn't ready.
Okay. Who's that?
C3. I think he's a C3.
Is Lewem?
Eric.
Okay.
Is his name?
Yeah.
I don't know if he's C3 or contact back here.
He is a GPDC lawyer. So anyway, all right. Well, we'll get updates on that. I just wanted to know about your two situations. Okay, thanks. We have Ms. Willingham now. My thought, well, we'll go in whatever order you want. If we could take care of folks who are on bond, then they can leave. I need to call kid number 2 to make sure he's up because he's getting himself to his exam. Kid number 1 is done with his exam and is in study hall. So I'm gonna go make sure kid number 2 is awake. And then what plea are we gonna do? I think Horton and King were the two. I don't know that we can squeeze both in before I have to go, but you guys can draw straws as to who's going to go first. Were you standing up for a different matter?
Sure, I wanted to make sure the court knew that in position number 4, Anthony Johnson arrived.
Oh, you're Mr. Johnson. Not a problem. Were you in Arkansas for a while too?
Yes, sir.
Okay, where is home for you? Atlanta, Georgia. I appreciate you working your way in here. Mr. Jones, your lawyer, is working through some pretty serious family stuff and was excused from being here today. And your case is being continued. I think, Ms. Willingham, you had said this was one that might work out, but it has been really getting Mr. Jones plugged in.
Yes, sir.
Okay, so Mr. Johnson, let me make sure we've got a good address for you in the system so that you get notice, but we don't reach out to you. I mean, you'll get something in the mail. My team and in particular the prosecutor would be contacting your lawyer and not you. But let me make sure. So I've got an address on Childs Drive. Okay, good. Then you'll get stuff in the mail. More importantly, we'll be reaching out to Mr. Jones, and he thinks that by the next trial calendar, he should be back in action. It sounded like from the prosecutor that your case might well work out. Obviously, that's a decision for you and Mr. Jones to make as well. And he's very capable of taking it to trial if that's what needs to happen once he's worked through the situation he's working through. Okay? Any questions? Okay, I appreciate you being here. I will take you off the bench warrant list and you are free to go. Thank you, Ms. Feely, for bringing that to my attention. All right, so you all decide King versus Horton. I'm going to go make sure my kid's up and then we'll jump right into it.
Thank you, Judge.
I can always help if you need a break. You try to get your walk through. Yeah. Like I can basically just share.
Yeah. Yeah, for sure. Yeah.
Okay, yeah. So, yes.
Hey, Mr. King, come on up. So did Mr. Horton just decide to go get lunch?
I just saw him walk out the door, so.
Okay, we'll see. We may be able to do both. We'll see. Some of these, Mr. Lloyd maybe took a little longer than the average bear. Hi there.
Yeah, when the disposition.
You were taking pleas elsewhere, your plea machine. Everything good with Judge Leffridge?
Yes.
Good. Do you have more pleas over there or that was it?
It was actually on Friday, and I thought this calendar started at 1. So when she asked about coming to finish it at 9:30,
Got it.
I said, sure.
Yeah. No problem. We will be back here at 1, so that was partially accurate.
Correct.
All right, Ms. Rivers, are you ready for some more pleas?
I'm ready.
Great. Okay. I'm happy to report not only was my kid up, he actually was already at school. Yeah, I was very surprised. Like, I'm not school, Dad. Could you get off the phone? Just need to make sure you didn't miss it. AP exam. All right. These are positions 23 and 24. Both are State versus Will King. Mr. King is here in court with his lawyer, Ms. Wood. Ms. Willingham represents the state on both these cases. Why did you not have the case we just took a plea on? Was it Mr. Whitenhour's at some point?
No, Your Honor, I think it was because of the fact that they had never lived together or had any children together, so.
Okay.
It was a trial on the thing.
Fair enough.
Qualifying factors to get to.
You have to cohabitate or co-create. Okay. All right. Got it. Well, Ms. Willingham has both of these cases. Mr. King, you've sat through a few pleas by now, so you know how this is going to work. You'll be put under oath. Once you're under oath, please answer truthfully all the questions, and please let Ms. Wood or me know if you've got any questions of your own. Okay.
All right.
You're not under oath yet, so you don't have to answer truthfully, but are you a Steelers fan or is that just a jacket you like to wear?
It just went with the outfit.
Okay, went with the outfit. All right,
I'm
good.
a Chiefs fan.
You're a Chiefs fan. Oh, that's even worse. All right. I promise that won't affect my sentencing decision, but I'm glad you're not wearing a Chiefs jacket. All right. So let's get started.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Please state your name, your age, and your date of birth.
You can put your hand down now.
Will Otis King III, April 3rd, 1992. I'm 31 years old.
Are you now under the influence of any medicine, drugs, or alcohol?
No, ma'am.
How far did you go in school?
Got my GED.
Can you read and write in the English language?
Yes, ma'am.
Have you had the opportunity to review the document that charges you in this case?
Yes.
Do you fully understand the nature of the charges pending against you?
Yes.
And so we're clear, I didn't get the indictments. It's actually, you're going forward on
I'm
both.
sorry, yes, indictments.
Yeah, it's 2 documents that charge you. It's 22 SC 185 230 and 22 SC 185 231. You're one of those rare folks where you have consecutively numbered indictments.
By pleading guilty today, you're giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes, ma'am.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes.
The negotiation as to 22 SC 185 230 is 5 years to serve 160 days with a balance probated. And as to 22 SC 185 231 is as to count 1 and 3, 5 years to serve 160 days with the balance probated. And as to counts 2 and 4, those will be authorized. You're pleading guilty today to is that what was discussed with you by your attorney?
Yes, ma'am.
You're pleading guilty today to 2 counts of battery, family violence, subsequent conviction, each with a minimum of 1 year and a maximum of 5 years, and aggravated assault with a minimum of 3 years and a maximum of 20 years. Are you now serving any other sentence in confinement, or are you on probation or parole for anything anywhere?
No, ma'am.
You heard me tell the court what the negotiation is in this case, which is 5 years to serve 160 days with the balance prorated. Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which is 30 years?
Yes, ma'am.
Do you further understand that you may not withdraw your plea once the court pronounces sentence?
Yes.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including but not limited to that you are not to violate the criminal laws of any governmental unit. Under the special conditions, you are required to have no violent contact with Mayciona Fuse, Mayciona, Fuse, Fuse, complete family violence intervention program, no weapons, drugs, or alcohol. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No.
Are you satisfied with what your lawyer has done for you in this case?
Yes.
Do you have any more questions for your lawyer before we go on?
No, ma'am.
Have you understood everything I have asked you so far?
Yes.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes.
Is your decision to plead guilty made freely and voluntarily?
Yes.
Did you, in fact, commit the offenses to which you are pleading guilty?
Yes, ma'am.
Are you a United States citizen?
Yes.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You have 4 years from the date the sentence is entered for the felony offenses and 4 years from the date the sentence is entered for felony offenses. Do you understand these time limits?
Yes, ma'am.
Do you understand that you are not allowed to possess firearms during the course of your probation?
Yes.
Do you understand if you are found in possession of a firearm, you could be charged with another felony which carries up to 10 years in confinement?
Yes.
Your Honor, if the state were to proceed forward with trial, the state would prove beyond a reasonable doubt that in 22 SC 185230 on April 1st, 2022, King requested that Fuse drive his mother's car to pick him up at 3402 Eisenhower Circle, Southeast Atlanta, Georgia, in Fulton County. When Fuse got to the location, she left the vehicle running with her belongings in it. When Fuse knocked on the door, she stated King was acting weird, at which time she pushed King aside and saw another woman. The two began having a verbal argument, which turned physical when King grabbed Fuse by her braids and dragged her out the back door, subsequently tearing out some of her braids. In indictment 22 SC 185231, on July 8, 2022, officers responded to 1005 Baldwin Street, Southwest, Atlanta, Georgia, Fulton County, in reference to a dispute. The 911 caller stated she could hear Fuse screaming, "Call the police," and "Please stop hitting me." She could also hear a male voice telling Fuse to shut up. When officers arrived, they knocked on the front and back door multiple times before Fuse answered. When she came to the door, she appeared distressed and had visible bruising, and lacerations to her face, hands, and neck. She stated that her and King got into an argument when she tried to end the relationship. King got angry and got on top of Fuse and began striking her repeatedly in the face with his fist. She tried to escape by running into another room, but King came behind her and put her in a chokehold. He stopped when he heard police knocking on the front door. He then forced her to go downstairs with him and refused to let her open the door. When officers moved to the back door, King fled out the front door. Are the facts of this case, as I previously told the court, generally and accurately true, Mr. King?
Yes, ma'am.
Your Honor, the state has had an opportunity to speak with Ms. Hughes. It took us a while to track her down, but she is hoping that her and Mr. King can rekindle their relationship. She does not wish to move forward. And the state felt that this would be the best resolution to ensure that Mr. King is unable to do this again without more repercussions.
So Ms. Fuse's view is that staying with or getting back together, I'm assuming there's a bond in place that says they're supposed to stay apart. I don't know how effective that is, but either way, Ms. Fuse doesn't want things to end.
Correct, Your Honor.
Do they have children together?
They do not.
Okay. How do you say Ms. Fuse's first name?
Maciana.
Okay. Well, that explains or partially provides the answer to a question I had for you, which was, I just took a plea where the state asked for 5 years to serve for what sounds like, other than a gun being involved, some similar conduct. And here the state's not asking for 5 years to serve. And every case is different and the dynamics are different, different risk factors, et cetera. But you have a victim who is not interested in pursuing these charges. Not that it's her call, but she could make this more difficult for a presentation to the jury.
Yes, Your
Okay.
Honor. And I mean, being completely forthcoming, yes, the state, in preparation for trial, not sure whether Mr. King would have gone forward with a plea. We did get to Ms. Hughes, we got her served, and she still is just as adamant. I know sometimes when, once we get a subpoena, we sometimes can have a conversation that is a little bit better for us.
Yeah.
This one, not so much.
Okay.
So,
All right. Got it. Okay. Ms. Jackson, what can you tell me about Mr. King's criminal history, if any?
He has 20 cycles. The last arrest was December the 29th, 2022 in Clayton County for a probation violation. He does have prior felony convictions. It's one in 2019 out of DeKalb County for aggravated assault, one in 2018 out of Clayton County for false imprisonment and battery, family violence, a felony. And there was one in 2015 in DeKalb County, cruelty to children. And there's one in 2014 out of Clayton County for possession of marijuana with the intent to distribute. And there was an additional one in 2014 out of Clayton County for fleeing or attempting to elude an officer. And there was one in 2010, a theft by receiving stolen property. And he received first offender treatment in 2009 out of Clayton County for theft by conversion and theft by taking. That case was sealed March the 14th, 2014. Nothing in addition, Your Honor.
All right. Thank you. Ms. Tucson, is Mr. King on probation for any of the cases we just heard about?
He's on probation in DeKalb, 18 CR 44697, and it ends in 5 months.
Okay. Got it. Thank you.
A probation supposed to be over with.
Okay, well, someone from probation says it's not over with, so that may be something you'll need to look into. So Ms. Wood, tell me why this is an outcome that makes sense. It's a tough juxtaposition for Mr. King. He's got a messy criminal history. He's got some convictions for family violence, battery, and aggravated assault, cruelty to children. These 2 incidents, and I appreciate Ms. Fuse may not be real enthusiastic about going forward. At least one of them, law enforcement, it sounds like, would be able to testify. She answers the door and she's beat up. So how do I get comfortable with a time served sentence?
Yes, Judge. I also spoke with Ms. Hughes last week. She was very polite. She was very clear that she had no interest in speaking any further about this case, either with me or with the court. Mr. King has informed me, while they don't have contact, apparently she has contact with his family members, and she helps take care of his children, even though they don't share the children together. And that is an arrangement that they plan on keeping intact moving forward. And so we would ask the court to consider no violent contact with Ms. Fuse. The first incident, I believe it's the April 2022, the one where the braids were pulled, on the body camera, Judge, she's ticked off. She's more mad that he was with another woman than she was about her braids, in my opinion. I think that would be my part of our argument. Mr. King maintains that Ms. Hughes burst into the door and went after the other lady. And so it was sort of, he was just trying to separate the two for that case. The second case is a little more tricky because there are witnesses that call 911 that are outside hearing a commotion, Judge. He's accepting responsibility. He realizes it's not a great look given his history. It's time for him to actually learn how to deal with his anger and how to actually move forward when there is an issue with a significant other or anyone in general, Judge. And so that's why we feel that it's appropriate for him to have straight probation with the Family Violence Intervention Program. He's gainfully employed. He's been a hardworking employee of Environmental Stoneworks in Cobb County. He lays cement for a living. So for the past 7 years, he's done that. Judge is 31 years old. He does have his GED. He has 2 children. He's a Grady baby. He did serve 161 days on this. So we would ask that you accept the state's recommendation.
Okay. How old are your kids, Mr. King?
6 and 4.
And Ms. Fuse helps take care of your kids?
Yeah, she and my kids every other weekend. Her and my kids' mother has a relationship since we've been together.
Ms. Fuse and the mother of your kids are friends?
Yes.
Okay. And Ms. Fuse spends time with your kids every other weekend?
Yes.
And your kid's mother has the other weekends, or you've got the other weekends?
No, it's me and the kids' mothers rotate every other weekend. So even though me and her haven't been together, me and her child has a bond, and her son and my son has a bond. So she still gets them.
Got it. Ms. Fuse has her own kids?
Yes.
And her kids are close to your kids?
Yes, she still gets them on the weekends.
Got it. Okay. And where are the kids during the week?
With their mom. One stays in DeKalb and one stays in Douglasville.
2 different moms?
Yes.
Got it. Okay. And you've been with this same company for 7 years?
Yes, I came home from prison in 2016 and I got a job like 2 months later. Actually in Mableton, Georgia.
Okay. What were you in prison for in 2016?
I went to prison for the charge from Clayton County for they charged me with manufacturing marijuana, VGCSA.
Like growing it?
Yeah, that's what they charged me with.
Okay.
VGCSA, yeah.
Okay, got it. And what kind of hours do you work out of this? Do you go to Mableton to work and make concrete there, or you go to sites?
No, you actually go to Mableton. They make the concrete foundation for the new homes being built.
Okay, so it's prefab.
Yes.
Got it.
I go like 3, 4 in the morning and get off like 3 in the afternoon.
So 12-hour shifts?
Yes.
3 a.m. All right. But what days of the week?
It's just Monday through Friday and every other Saturday.
All right.
Saturdays rotate.
Got it. Okay. You are going to have a choice to make here. I am going to give you either a sentence of, I'll spell it out count by count, but you two need to talk. A sentence of 5 years to serve 6 months. You haven't served 6 months yet, so you'd go back into custody now. Or, because that's about 20 days, it's 5 years to serve. We'll do the math. So it's basically time served plus 10 weekends in jail, where you would check in Friday after work and get out Sunday. So it would be 10 2-day stints in jail. Either way, it's about 3 weeks, 20 days. as an additional consequence for these back-to-back cases while you are on active probation and having already had family violence battery conviction. So I'm happy to answer questions about how those two things would work if you want to do that before the two of you talk. But so you're clear, it's not I don't like either of them. There's no option C. It is A or B. And I'm structuring it this way mostly because I want to support your work. You've been working hard. You support two kids. You may support parents, who knows? And you've had the job for a long time. So I want you to be able to maintain that. I'm kind of underwhelmed with all this other stuff. At some point, you're going to need to treat the women in your life differently. And if it's in front of me again next time, we won't measure it in months. So you and Ms. Wood should talk for a second and let me know which of those makes the most sense for your schedule.
Thank you, Judge.
Sure.
Guess we'll do the weekends.
Weekends it is. So let me work through all the things I need to say. First, Mr. King, I find there's a factual basis for both of your pleas. You and Ms. Fuse sounds like have had a rather dynamic relationship. And I can understand why Ms. Fuse was upset in April of last year. And you may literally just have been trying to keep two people apart. But you may need to manage your other rendezvous in a way where Ms. Fuse doesn't walk in on one of them. The second one in July of last year, there's nothing good to say about that. And it may be that you and Ms. Fuse go at it, but you need to figure out a way. You're not a huge guy, but you're still the guy in the situation. And if things are getting testy and people are yelling at each other, you just walk away. You need to figure out how to make that happen because law enforcement, when they show up at the scene, they're going to take you away each time. It doesn't matter who starts it. And so it's just in your interest and frankly, your kid's interest. I'm a little more focused on them than on you. You're a big kid. And if you go back to jail, you deal with the consequences, but your kids don't have dad around. They don't have them around physically. They don't get to see them, but they don't have them around financially as well. And you need to step up for them. So I find there's a factual basis in both cases. I also find that your pleas are knowing and voluntary. No one's forcing you to enter these pleas, and you've understood the things we've talked about. Do you agree with that?
Yes, sir.
Okay. I'm sentencing you pursuant to the Probation Options Management Act. And all that means is that while you're on probation, if you have a minor violation, you and probation will work through it. But if it is a violation of the special conditions I'm about to impose, or if you get arrested for something else, that comes back to me and we will figure out what the consequences are for that. I will sentence you in 22 SC 185230 to 5 years to serve 5 months with the balance probated. You'll get credit for all the time you've been in. You were in for more than 5 months. Special condition of probation number 1 is 10 consecutive weekends of going to jail. You will check in. What's a reasonable time on Friday to make it? You got to get from Mableton to Rice Street.
It's not too far, so no later than like probably 5.
Okay. Do you think you can make 5? Because I don't want to set a time like, I can't make that.
So 6.
Yeah.
6?
Probably be.
All right. So you will report to Rice Street at 6 o'clock. You're going to want to bring your you're going to get your sentence. You'll leave before you get it, but Ms. Wood will get it to you. We'll tell you, I've had defendants who have one of these conditions. They show up at the jail and the jail's like, we don't just take walk-ins. If you get escorted in handcuffs, they take you. So you'll need to bring what is technically called your final disposition, but your sentence, you bring it with you. See, look at this. It says 10 weekends in jail. Then they say, oh, all right, we'll take you in. You spend a weekend in, you get out Sunday by 6, usually a little earlier, and you're back on your way. The first weekend would be this weekend, but that may be too soon if you need to schedule things out. So I don't mind starting the following weekend. You tell me.
I start the following week.
Okay, so that would mean May 19th. That's a Friday. That's 2 Fridays from now. May 19th by 6 o'clock. If you get there earlier, you get out earlier, but no later than 6 o'clock, you're checking in. And that will be for 10 consecutive weekends.
Yes, sir.
Special condition number 2 is no violent contact with Ms. Fuse. So you guys can interact. Violent contact would be a crime anyway, but it would be a violation of your probation. And the difference between a regular condition of probation and a special one is that if I designate it as special and I find that you violated it, I can revoke all of your probation. If you have a technical violation, I'm making this up. Let's say you test positive for something because you had a drug screen. One, not going to get you in trouble. We'll see if you need to have any drug treatment, but that kind of thing, I can only revoke so much if I'm going to, but if you violate a special condition, I can revoke the whole balance, which would be a fair amount of time for you. Special condition number 3. So 1 is those 10 consecutive weekends. 2 is no violent contact with Ms. Fuse. And 3 is that you complete a family violence intervention program. That's a series of classes. It's not just one, but it's one every few, maybe one a week for a bunch of weeks or every few weeks, but you got to complete the whole program. In 22 SC 185231, your sentence for count 1 is the same as in the other case. It's 5 years to serve 5 months with the balance on probation, credit for time served. Count 2 has been dismissed. Count 3, same sentence, 5 years to serve 5 months, balance probated. That'll run concurrently with count 1, and count 4 has been dismissed. And then it will be the same 3 special conditions of probation. So the 10 weekends starting on the 19th, no violent contact with Ms. Fuse, and family violence intervention program. You only need to take the class once. You'll get credit in both situations. Ms. Willingham, any other conditions in Mr. King's cases? Ms. Wood, anything else on behalf of Mr. King?
No, Your Honor.
Okay. Ms. Tucson, can you tell Mr. King what he needs to do to connect with Fulton probation?
No problem. Mr. King, will you be living in DeKalb County?
No,
Still?
man, I stay in 3441 Eisenhower. That's EISENHOWER Circle. That's Atlanta, Georgia 30354.
And what is your phone number?
678-818-6581.
Okay, I'm gonna call you and give you the reporting instructions because it looks like you are still listed under DeKalb. So it's gonna have to be transferred from DeKalb back to Atlanta. So I'm gonna get further clarification and give you a call.
Yeah, because I was just reporting in Atlanta by Memorial Drive.
And that's what you'll do. You could have probation out of Chatham County where Savannah is, but you were supervised where you live.
Yeah.
I think what Ms. Tucson was pointing out is that you seem confused about whether you still have probation out of DeKalb. Her system says you got a few more months.
All right.
So just you're going to want to make sure if you still are on probation out of DeKalb that everything's going smoothly with that. That doesn't mean you have to report to DeKalb. You'll go to Memorial Drive like you've been, say, hey, I'm here, I got 2 new cases. And then that officer presumably will be managing all your business.
All right.
Okay. All right. If that is it, thank you, everyone. And you'll get contact about when you need to have that first meeting with probation.
All right. Thank you.
And don't miss your first date at Rice Street.
All right. And then I'll just take that to the jail.
And I'll text you all the instructions. Okay.
As far as
So, Mr. Horton, I'm not going to be able to fit your plea in before I have to go pick up my kid and bring him back here. So I see you've got someone here for you. You can relate. So if you want to go grab some lunch, we will do your case first up after lunch. I'm sorry we couldn't fit it in, but apparently you lost the arm wrestle to Mr. King. Although it looks like you'd win that arm wrestle. So my guess is it wasn't an arm wrestle. But we need to pause now. And why don't we try starting back up at 12:50, just to keep you waiting as little as possible. You guys are welcome. There's a place, American Deli, right across the street, or Ms. Feely or Ms. Wood. Who's got Mr. Horton? you could give Mr. Horton ideas about lunch. But we'll take that up first. According to my list, we still have Barry, Jones, and McCoy all in custody. Are those all Willingham cases? Okay, we'll do those after we do Mr. Horton. And that should clear the decks for today. Mr. Jordan, I saw you sent the thing for Ms. Smith, so I'll take a look at that. And we should be all set. Okay. Thanks.
To be honest with you, I think his job is already tracked.
All right, Ms. Rivers, can you hear us from 8D?
Yes, I can.
Great, then we are back in action. Ms. Wood, are we going to do Mr. Horton's plea now?
Yes, sir.
Great, Mr. Horton, thanks for your patience. If you'll come on up to the podium, please. All right, Ms. Wood, are you ready?
Yes, Judge.
Ms. Willingham?
Yes, Judge.
This is position 10 on the trial calendar, 22 SC 182992, State versus Morris Horton. Mr. Horton, you're charged with aggravated assault and family violence battery, I think misdemeanor version of that. And Ms. Wood tells me that you are prepared to enter a plea at this time. Is that correct?
Yes, I am.
Okay, well, you've sat through a few of those today. You know the routine. Ms. Willingham's going to put you under oath. If you've got any questions of your own because something's going differently than the way you expected or it's otherwise confusing, will you let me know?
Yes, sir.
Okay. When you're ready, Ms. Willingham.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can put your hand down. Please state your name, your age, and your date of birth.
Morris Everett Horton, 07/14/1967.
So that makes you 55, 56, 50,
55.
55. All right.
How far did you go in school?
Graduate 12th grade.
Hold the microphone in front of you, please.
That better?
Yes.
Yes, much better. Thank you.
Sorry. Can you read and write in the English language?
Yes, ma'am.
I didn't hear how far you went in school. We had to.
I graduate
High school, college?
high school, Munich, Germany.
Okay.
Have you had the opportunity to review the document that charges you in this case?
Yes, ma'am.
Do you fully understand the nature of the charges pending against you?
Yes, ma'am.
By pleading guilty today, you are giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes, ma'am.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes, ma'am.
The negotiation in this case, as to count 2, is 12 months probation, and as to count 1, it will be non-pros. Is this what was discussed with you?
Yes, ma'am.
You're pleading guilty today to battery family violence with a minimum of 1 day and a maximum of 12 months. Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No, ma'am.
You heard me tell the court what the negotiation is in this case, which is 12 months probation. Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which is 12 months in custody?
Yes, ma'am.
Do you further understand that you may not withdraw your plea once the court pronounces sentence?
Yes, ma'am.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation.
Yes, ma'am.
Under the general conditions, you will be required to follow the general conditions of probation that probation will give to you when you meet with them, including, but not limited to, that you are not to violate the criminal laws of any governmental unit.
Yes, ma'am.
Under the special conditions, you are to have no violent contact with Andrea Davis, complete family violence intervention program, no weapons, drugs, or alcohol.
Yes, ma'am.
Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes, ma'am.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes, ma'am.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No, ma'am.
Are you satisfied with what your lawyer has done for you in this case?
Yes, ma'am.
Do you have any more questions for your lawyer before we go on?
No, ma'am.
Have you understood everything I have asked you so far?
Yes, ma'am.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes, ma'am.
Is your decision to plead guilty made freely and voluntarily?
Yes, ma'am.
Did you in fact commit the offenses to which you are pleading guilty?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You will have 12 months from the date the sentence is entered to file this petition. Do you understand these time limits?
Yes, ma'am.
Your Honor, if this case were to proceed to trial, the state would prove beyond a reasonable doubt that on August 28th, 2018, officers responded to 2910 Fifth Avenue Southwest, Atlanta, Georgia, in Fulton County, in reference to a domestic dispute. At that time, Ms. Davis stated she was in a verbal altercation with her husband, Morris Horton, about money. She stated the altercation began to get physical and the defendant struck her multiple times with a closed fist to her face, struck her in the face with his knee, and sat on her. She further stated that the defendant picked up a vacuum cleaner and struck her multiple times in the face. She had a swollen face and was bleeding from her nose and mouth. Ms. Davis told officers she believed her jaw was broken. In reviewing Ms. Davis's medical records, it was determined that her jaw was not broken. Further, Ms. Davis now represents in my interview with her that although the defendant did hit her with his fist multiple times, he did not hit her with a vacuum. And she further stated that she's not sure where that information came from. Your Honor, Ms. Davis, I believe, is present in court today. The state believes that the felony count should have remained. However, in speaking with Ms. Davis and taking into account that we don't know whether the vacuum was used or not, is why we chose to only proceed forward with the actual battery.
So the aggravated assault was the use of the vacuum cleaner?
Correct.
Okay.
And without her stating that it was used, we wouldn't be able to move forward with that.
Correct.
Your Honor, I did, based on the fact that we were reducing this to only the misdemeanor, the state did take a look at the defendant's criminal history. It appears that all of his charges are fairly old. It looks like the most recent one that I was able to find was 2003. It was a criminal attempt, and it was a drug charge, and everything else is the 90s and earlier.
Okay. Thank you. Ms. Jackson, good afternoon. Can you share the criminal history information you've got, please?
Yes, Judge. The defendant has 21 cycles. The defendant's last arrest was September the 24th, 2014, the City of Atlanta Police Department for driving without a valid license. There was no disposition for that arrest. The defendant does have prior felony convictions. So one in 2003 out of Clayton County for criminal attempt to commit a felony, and one in 1996 for possession of a firearm by a convicted felon, and one in 1993 for aggravated assault, and one in 1991 for the violation of the Georgia Controlled Substance Act, and one in 1988 for possession of a firearm by a convicted felon, and theft by receiving stolen property. And the defendant did receive first offender treatment in 1988 for theft by receiving stolen property. That case was sealed on July the 6th, 2017. Nothing in addition, Your Honor.
Thank you. Ms. Tucson, those all seem old enough that I assume Mr. Horton's not on probation right now?
Correct. You are correct. He is not.
Okay, thank you. Ms. Wood.
Thank you, Judge. Mr. Horton is 55 years old. He does have a high school degree. He's been here in Georgia since 1987. This is a 2018 case. Miss Davis has represented to our office multiple times. She has no interest in prosecuting. As you've heard, they're still together. They've been together since this incident. On the body camera, she is heard telling the officer they were both drinking. So, we won't squabble too much with the facts. Mr. Horton is just ready to get this behind him and move forward. We would ask the court to consider suspending the probation after completion of the family violence intervention program. Otherwise, we ask that you accept the state's recommendation.
Mr. Horton, are you working?
I get disability every month, but I work part-time.
What do you do part-time?
Security.
Where do you do that?
Spot on security. I work like, when he called me, I might work underground.
Different places. They'll call you and say, hey, could you work today or next week or whatever it is?
Yes, sir.
Okay. Have you been disabled all your adult life, or is that something that happened partway through your working career?
I was born illegally blind.
Okay. So you've had to work through that challenge from the get-go.
Yes, sir.
Okay. Are you and Ms. Davis married?
Yes, sir.
Legally married, common law?
Married.
Married. Okay. Still married?
Yes, sir.
Do you share the same household?
Yes, sir.
Is that your son who's here?
Yeah, that's my son.
Okay. How many other kids do you have?
4 more.
4 others?
Yes, sir.
Are they all with Ms. Davis or with other people?
With other people.
The only one who lives with you is the young man here?
Yes, sir.
Your other kids, are they much older?
Yeah, they grown. Most all of them grown.
Are they?
Except from a 16-year-old, she in California.
Okay. And the others are also not in Georgia?
Yeah, all of them in Georgia, except for I got one in Florida and I got one in California.
Okay. And what's your son's name?
Mason Davis.
How old is he?
12.
Any reason he's not in school right now?
He got suspended last week.
For what?
Fighting.
Mason, bad choice. Do you get to go back to school before the year is out? Pardon me? Tomorrow. Where are you going to school? Crawford Long? Okay. Did the other kid get suspended also? Is this your first suspension? How many do you get before they kick you out? 3? You done with suspensions? What was the other suspension for? Same thing, same kid? No? Any reason you're fighting? Oh, they're picking on you? Okay, well, I'm sorry that's happening. You're gonna need to figure out, kids are gonna pick on people. That's what kids do. You need to not, I don't know what it is you're doing to them. Don't hit them with a vacuum cleaner in particular. All right? Good. All right. Mr. Horton, anything you want to add?
Yeah, no, not really, Your Honor. I just want to apologize. I'm accepting responsibility, and I hope I don't never come in front of you no more.
Okay, I hope so too. Insofar as drinking was part of it, you taking any steps to moderate the drinking?
I don't even drink no more.
Why'd you stop?
It's because it started hurting my stomach.
Oh, okay. All right. Ms. Davis, anything you want to add?
I just appreciate being home.
Okay, well, he's home. He's coming back home too. All right. Well, Mr. Horton, I find there's a factual basis for your misdemeanor plea. You and Ms. Davis got into it almost 5 years ago. And this case popped up and you need to work through it. I also find that your plea is knowing and voluntary. You feel like anyone's forcing you to do this, or are you standing in front of me on your own free will?
I'm on free will.
Okay. Any questions about anything we've discussed?
No, sir.
Okay. Then I'll accept your, pardon me?
I'm just going to accept responsibility. That's all, you know.
Got it. That's what's happening. Then I'll accept your plea. And I will sentence you to 8 months of probation. Special condition of probation number 1, no violent contact with Ms. Davis. Obviously, she's someone important in your life, so you're going to be around her. But if you all get to disagreeing, which happens even amongst the best of us, You need to figure out a way to walk away if that's what you need to do.
Well, I'm gonna run, y'all.
Run away. That's it. Run away. Just don't crash into anything. You'll also need to complete a family violence intervention program, which is a series of classes that'll help you, help Ms. Davis, and may even help Will Mason there, because it's going to give you tools and techniques for dealing with contentious situations that don't involve you putting hands on. It sounds like Will Mason could benefit from that as well. But he's not going to the classes. You are. I think that's it. Ms. Willingham, anything else in the Horton matter?
Nothing further, Your Honor.
Ms. Wood?
No.
Okay. Mr. Horton, I will be getting electronically. Oh, I need to make sure this is okay. Mr. Horton, do you authorize my staff to sign the indictment indicating your misdemeanor plea?
Yes, sir.
Ms. Wood?
Yes, Judge.
And Ms. Willingham?
Yes, Judge.
Great. I think I forgot to do that for Mr. King, but
Just gonna say that.
yeah, but it's going through anyway. Mr. Horton, I'm gonna have you stay here. Ms. Wood may leave, although her colleague will still be here until misdemeanor probation comes to meet with you, just so they can get your contact information and you can get theirs. That way you'll know when and where to report.
Okay, yeah.
All right. So please don't leave until you've had that exchange.
Okay then.
All right. If there's nothing else, that'll be it for Mr. Horton.
I appreciate it.
Thank you, Judge. May I be excused?
Yes, ma'am.
Thank you.
Mason, no more suspensions, okay? I'm just telling you, kids who get lots, I was gonna say, if you don't want to, 5 years from now, all of a sudden you're standing up there with Ms. Wood, that's not where you want to be. You seem like a nice young guy, and you got a big future ahead of you, okay?
Thank you for that, we've been trying to.
All right, well, now you've heard it from someone else. All right, so Mr. Horton, you're not disappearing, right? Okay. Okay. All right, I don't see Ms. Feely. Is she back there? That's what I was hoping. All right, Ms. Woodward, you're done for the day and you've got nothing left on the trial calendar. Nice work.
Thank you.
Go line up some pleas on the plea and arraignment calendar.
I'm headed to registry, hopefully.
Have you found, I don't have numbers yet from the sheriff's office, that any of your clients are in very distant locales? We are hearing that jails that have extra space may be called upon and paid to house inmates. And I've only bumped into it once. I
think it was my guy in Oconee.
Ari Ratliff, or I think we're dealing with him this week, but
Yeah, he's back.
great. But beyond that, have you had anything like that?
I think he's my furthest one.
Okay. But further than Cobb? I guess what I'm asking is, do you do have clients who are not here or in Cobb?
So he would be my own, but he's back.
Okay.
I know, I think Carl Bennett was in Oconee, so there's a couple more.
How do you learn that? You go to Rice Street saying, I'd like to see Carl Bennett. You're like, you're not here.
But in Odyssey, it's Jail Odyssey shows it.
Yes.
And it shows where they go. It doesn't just say loaned out or not here.
So there is some guesswork involved. So for the Oconee guys, it'll say like loan out OCC. And then if you ask for clarification, the deputies will tell you that's Oconee. Or
Okay.
I have called up there to see who they've got.
Okay. We're working, if there is heavier reliance on some of these outlying county jails, we're working on either getting it clear in Odyssey or having maybe a weekly roster, because it affects how we do things too, because you can't just hop on the bus at Rice Street or get them over here so quickly. So, okay, thank you. Oh yeah, who are we doing first?
I believe Lawrence Jones is doing first.
Mr. Thrasher has a PF case. I rarely see PF cases. Okay, all right. All right, you're Mr. Jones?
Yes, sir.
How are you?
All right, you.
I'm okay. Mr. Jones, you are position 15 on our trial calendar. It's 22 SC 184065. You're represented by Ms. Feely, who's here in court with you. Ms. Willingham is the prosecutor handling your case. And Ms. Feely tells me that you are prepared to enter a plea in your case. Is that correct?
Yes, sir.
Ms. Feely, is this a plea where you all have agreed on a sentence?
Yes, sir.
Okay. Mr. Jones, in a moment, Ms. Willingham is going to put you under oath. When you're under oath, you'll need to answer her questions and mine truthfully and completely. I need you to let me or Ms. Feely know if you've got questions. Usually the questions come from this way towards you, but if there's anything that happens that confuses you or just isn't following the line of things Ms. Feely told you about, will you let us know?
Yes, sir.
Okay. And do make sure when you're answering Ms. Willingham's questions that you speak up. You are soft-spoken, which is fine, but the court reporter, who is virtual, needs to be able to hear you, okay?
Yes.
All right. When you're ready, Ms. Willingham.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I affirm.
Please state your name, your age, and your date of birth.
Lawrence James Jones, 5'9", 72'51".
Are you now under the influence of any medicine, drugs, or alcohol?
No, ma'am.
How far did you go in school?
12.
Did you finish high school?
Yes.
Can you read and write in the English language?
Yes, ma'am.
Have you had the opportunity to review the documents that charge you in this case, in these
Yes.
cases?
Is it just one case?
No, this is Jones. It's just one. Sorry.
Yes, okay.
In this case,
Yes.
do you fully understand the nature of the charges pending against you?
Yes.
By pleading guilty today, you are giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, the right to not incriminate yourself. Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes.
The negotiation in this case, as to count 1 and 4, is 5 years to serve 1 year with the balance probated. As to counts 2 and 3, those will be null pros. All counts will run concurrent. You are pleading guilty today to aggravated assault with a minimum of 3 years and a maximum of 20 years, and possession of a firearm by a convicted felon with a minimum of 1 year and a maximum of 10 years. Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No, ma'am.
You heard me tell the court what the negotiation is in this case, which is 5 years to serve 1 year with the balance probated. Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which is 30 years?
Yes.
Do you further understand that you may not withdraw your plea once the court pronounces sentence?
Yes.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including, but not limited to, that you are not to violate the criminal laws of any governmental unit. Under the special conditions, you are to have no contact with the victim, complete family violence intervention program, no weapons, drugs, or alcohol. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes, ma'am.
Has anyone used any force, threats, or promises which cause you to plead guilty against your will?
No, ma'am.
Are you satisfied with what your lawyer has done for you in this case?
Yes.
Do you have any more questions for your lawyer before we go on?
No, ma'am.
Have you understood everything I have asked you so far?
Yes.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes.
Is your decision to plead guilty made freely and voluntarily?
Yes.
Did you in fact commit the offenses to which you are pleading guilty?
We're in a little bit of a difficult situation. I did talk with him maybe should have talked more about the Alfred plea, because he is doing this because he understands that there is evidence from which a jury could convict him, but at the same time, not fully confessing guilt.
So, Mr. Jones, there is something called an Alford plea, which is maybe better described as a best interests plea, when a defendant says, I don't agree with the things you're about to say. Maybe I did some of it. Maybe there's more to it. But regardless of that, Ms. Prosecutor, I'm going to go forward because it's in my best interest, meaning Mr. Jones's best interest. I don't want to go to trial, run the risk of the jury, maybe seeing pictures of Ms. Good or who knows what will come out at trial, and that you've decided it's in your best interest to go forward with the plea, even though you're not admitting that you did all the things the state said you did. Does that describe your situation? Yes? You need to say yes or no?
Yes.
Okay. You understand that that's still a conviction. So you're saying, it didn't happen quite the way the state said, but I want to go forward.
Yes, sir.
Okay. It'll still show up on your criminal history.
Yes, sir.
Okay.
Are you a United States citizen?
Yes.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You will have 4 years from the date the sentence is entered for felony offenses and 12 months from the date the sentence is entered for misdemeanor offenses. Do you understand these time limits?
Yes, ma'am.
Do you understand that you are not allowed to possess firearms during the course of your probation?
Yes.
Do you understand if you are found in possession of a firearm, you could be charged with another felony, which carries up to 10 years in confinement?
Yes.
Your Honor, if the state were to proceed to trial, we would prove beyond a reasonable doubt that on November 9th, 2021, officers responded to 1104 Oakland Drive, Southwest Atlanta, Georgia, Fulton County, in reference to a dispute. Good reported that Jones came home on the night of the incident very upset. Jones accused Good of infidelity because she had a male friend over that day, Kenny Williams. Good told Jones she had not cheated on him. Jones grabbed Good, pulled her out of the house, and threw her onto the porch. Jones then pulled out a firearm and pointed it at her head and stated that he would kill her. Williams told Jones to chill out and calm down. Jones then told Williams to stay out of his business. Williams threw.
Oh, so this other gentleman is actually there for this exchange.
Yes, Your Honor. However, we don't know who this other gentleman is. He is not there by the time the officers get there. And
I mean, we know who he is in the sense that Ms. Good says his name is Mr. Williams.
correct. And
So when Mr. Jones showed up being unhappy about alleged infidelity because someone was around earlier in the day, that someone is actually
was still there.
still there.
Yes.
Got it. That's what confused me, is that Williams said, chill out. I'm like, what,
Yes.
who's that? Okay.
Williams was still there, Your Honor, at that time. Jones then locked Good out and turned off the lights. Good then called police. Good stated that while she was on the phone with dispatch and awaiting officers' arrival, Jones kept trying to leave out of the back door, but she would not let him leave. Well, she would meet him there and stop him. Good stated that Jones snuck out of one of the side windows and took off on foot. However, Good followed Jones as he attempted to flee and listed the street names for dispatch. Jones can be heard from the 911 call threatening and cussing at Good. When officers arrived, both Jones and Williams were gone. Good gave a description of Jones and the gun that he used. Good told officers that Jones has been becoming more and more aggressive throughout the relationship. She claimed that he was doing drugs. Officers observed lacerations on Jones' right hand from hitting the porch. Your Honor, obviously there is a firearm used in this. However, the state has made ample attempts to try and locate the victim in this case. There were drugs involved, it looks like, on both sides. And with that, we have been unable to actually have a real conversation since this case was indicted. And based on that, because we do still want the defendant to have to be held accountable, the state has made the decision that this is the best way to resolve this.
Okay. So not only have you not had a chance to talk with Mr. Williams, you haven't had a chance to connect with Ms. Good.
Correct.
Got it. Okay. Understood. Ms. Jackson, can you share criminal history information for Mr. Jones? I know he's got something out of Florida because that's mentioned in the indictment.
Yes, Your Honor. The defendant has 41 cycles. The defendant's last arrest was March the 11th, 2009 in DeKalb County for 3 counts of battery in obstructing or hindering a person from making an emergency telephone call and 2 counts of simple battery. Defendant does have prior felony convictions. They're out of Florida. One in 2002 for possession of a firearm, ammo, electric weapon by a convicted felon. One in 1998 for possession of cocaine. One in 1997 for possession of cocaine. It's an additional one in 1997 for possession of a weapon by a convicted felon. And one in 1995 for possession of cocaine. The defendant does have a misdemeanor conviction. It's in 2009 out of DeKalb County for simple battery. Nothing in addition, Your Honor.
Thank you. So that's all pretty old. What's Mr. Jones been up to since then, Ms. Feely?
So he was working for the last 13 years at Atlanta Peach Movers. He also works with his brother who sometimes comes to court. I didn't see him today doing landscaping. He is 50. He'll be 51 tomorrow. And he's originally from Florida, but has lived in Atlanta the last 20 years or so. He's divorced, has grown children. As you heard, a high school grad. We are asking the court to accept the state's recommendation. We would ask the court to consider waiving his probation fees because he has been in jail for 488 days, at least for some period, to help him get on his feet. As the court heard, this case was messy. I think it's a defensible case, but the time served, it's his decision to make, and the time served was more persuasive than anything I could say. So does that pretty much sum it up, Mr. Jones? Okay.
All right. The record should reflect that Mr. Jones nodded when Ms. Feely asked. Does that pretty much sum it up? Mr. Jones, how long had you and Ms. Good been in a relationship, dating, whatever you want to call it, when this situation happened?
About a year, Your Honor.
Okay. And have you been in custody since then?
I've been in custody 16 months.
I know it's 16 months. I just did the math. But you were arrested then and you've not gotten out? Or I don't remember. I don't know when you got arrested.
I got arrested January the 5th.
Of 2022. In connection with this?
It's for this.
For this. Okay. All this other stuff we heard about, except one thing in DeKalb County in 2009, is all pretty old, and that's all Florida.
That's old.
Okay.
I don't even get in trouble, Your Honor. It's just some lies come up. I'm gonna accept this as a man and keep it moving, man.
Okay. The situation down in Florida, were you involved with drugs for the money, or were you involved with drugs because you had an addiction?
I was young. That just was the way of life back then, you know.
Okay, I mean, but it was a line of work as opposed to, and I'm asking only because I want to make sure
Yeah.
we're giving you,
It wasn't no use.
okay,
Yes.
that's right. You know where I'm going. So I don't need to worry about getting you evaluated, because if what was behind the situation with Ms. Good is you were high and she was high, let's not have you high. And then this kind of stuff won't happen, but you're telling me that's not it.
Nah, that's
Okay.
okay.
All right. Got it. Mr. Jones, do you authorize my staff to sign the indictment indicating your offered plea to counts 1 and 4?
Yes.
Ms. Feely
Yes, Your Honor.
and Ms. Willingham?
Yes, Your Honor.
Okay. Well, Mr. Jones, I find there's a factual basis for these charges. That's not me taking sides. It's me acknowledging what it sounds like you've acknowledged, which is if Ms. Willingham was able to share with the jury all the things she said went down, then it could turn into a he said, she said, and that doesn't always go well for the he in the equation. And so as I understand it, you are wanting to work this out with the time served recommendation rather than wait for a trial and run the risk of that trial not going well. Is that correct?
Yes.
Okay. Well, I do find that the state could prove those 2 charges. I don't know if they would, but there's evidence there that would support a guilty verdict. I also find that your plea is knowing and voluntary. And those 2 terms on the knowing side means you've understood everything we've talked about. Any questions about anything?
No, sir.
Okay. And voluntary, you know what that means. No one's forcing you to do this. You've decided, since we're calling it a best interest plea, that it's in your best interest to go forward today. Is that correct?
Yes.
All right. I'm sentencing you pursuant to the Probation Options Management Act. And all that means is that while you're on probation, if you have a minor or a technical violation, you and probation work through that. We don't need to get lawyers in the mix. But if it's more serious, you get arrested again, or you violate a special condition, then that comes back to me, and you will have a lawyer, and we'll work through if there was a violation, and if so, what the consequences were. Okay. I'm going to sentence you on count 1, aggravated assault, to 5 years to serve 1 year and 4 months. You'll get credit for all the time you've served, and you've done a little more than 1 year and 4 months, with a balance on probation. Count 4 will be the same sentence, and it will run concurrently with count 1. There will be 3 special conditions to your probation. Number 1 is no contact with Ms. Good. I don't know if you all have been talking on the phone since you've been locked up.
I used to. I don't talk to her.
Okay. Well, let's just keep it that way. If for some reason that's the only woman left for you in this world, you need to reach out to Ms. Feely and let the prosecutor talk to Ms. Good. Ms. Good has been scarce, but what all I'm saying is sometimes the people are destined to be with each other. If you and Ms. Good decide that's what needs to happen, I need to modify your sentence. So you could have contact with Ms. Good, and the prosecutor is going to want to have a chance to talk with Ms. Good to make sure she's okay with that.
Oh, man, I ain't got nothing to say to her.
Good. We'll keep it that way. You got nothing to say to her.
Ooh, man.
So don't go in that direction, because that's actually what your probation says. Number 2, you'll complete a family violence intervention program. And that's it. Those are the 2. I will waive your probation supervision fees for the first 4 months of your probation while you plug back in. Maybe your brother can help you. You're working with moving company, who knows what. You've been out of commission for a while, so it may take a minute to start working again. Do you have a place to live when you get out? Yes?
Yes, yes.
Good, because you're going to be telling probation about it in about 10 seconds. Anything else, Ms. Willingham, in Mr. Jones's case?
Nothing further.
Ms. Feely?
No, Your Honor.
All right. Ms. Tucson, why don't you chat with Mr. Jones for a sec to get the information you need?
All right, thank you. Mr. Jones, I need an address and a phone number for you, please.
The address gonna be 1602 Sandtown Road, Atlanta, Georgia.
And could you say the name of the street again?
Sandtown
SANDTOWN
Road.
Thank you. And do you have a phone number at the moment?
No, I don't. I'm gonna get a phone first thing tomorrow when they let me out.
Okay, do you know where probation is?
No, I need a address.
Okay, I'm gonna give that to you. It's 276 Memorial Drive Southwest. It's right around the corner from the courthouse.
Yeah.
Miss Feely's writing it down.
What's the zip?
And we'll get him a piece of paper. They used to have these nice forms where you just like check these boxes as to which office it was.
We do have forms, and I could definitely bring some to have them in court when I'm not there. That's no problem.
Okay.
But yes, it's 276 Memorial Drive Southwest. And I can give you the phone number if you'd like. Field offices, because we have 2. Fulton, if you will. 404 463
Okay.
0410.
Thank you.
Okay, and you're going to want to report, Mr. Jones, on the 25th of May.
Just anytime that day?
8 a.m.
Oh, so that's the day I report.
Yeah, don't miss that appointment. That's an important one.
Today's the 8th. This is a Thursday, May 25th at 8 a.m.
Is that it? I'm good.
I believe so.
Is that a piece of paper he can keep?
Yes.
Okay. All right. Good luck, Mr. Jones.
Mind if I do?
So, Your Honor, may I ask the question before I go out?
You may.
So what that leave me on, 3 years, how many months of probation?
8.
Okay. And I'll be released today?
No.
Probably.
Tomorrow. They don't process it that fast. If you're not out by Wednesday, call Ms. Feely and we'll fix it. But tomorrow,
No.
okay.
And I
So
will,
they
Oh, right, you're up in Cobb. Definitely not today. We don't promise same day service.
I will watch the system though, so I'll be able to see the exact date.
Oh.
Oh, sorry. Can you get it? Got it.
All right, what makes sense for you next, Barry or McCoy?
We're still talking a bit.
On both? Okay, I'm just gonna work right here.
We're gonna change our announcement on Mr. Barry.
Oh,
I've had a couple of discussions with him today, so positions 6 and 7 are ready for trial.
should we get anything on the record, like what the offer is and lock all that in? Let's do that. But let's let him think a little longer. Should we bring Mr. McCoy out?
So I think we can get this done today. The issue with Mr. McCoy is he has been in Department of Corrections custody. And so my phone conversations with him, he was always, I want a concurrent sentence with my current DOC sentence. And it seemed like that was what was going to work out.
Yeah, isn't he in on if I'm remembering, if it's the same Mr. McCoy, there was a gun and drugs and he ran behind a MARTA station and they found it was before you. But I think this is the same guy.
So Once he came to Rice Street, I was able to sit down with him and actually go over the discovery and everything, which is why I wanted him produced a little
Yeah.
early. And so now we are having some difficulty about, I think that the state has evidentiary and witness issues on some of these. And so I'm not quite comfortable just pleading him out to these 2 indictments based on my conversations with him, particularly the gun charge after what happened with my trial. Mr. Clark, I understand now how serious the gun convictions can come back and be problematic, as well as the drug convictions. So the state hasn't even tested most of the drugs with the understanding that it was going to be a plea. But
And Judge, to that, yes, from the time I came into the courtroom, this case has been on several calendars and it's always been represented to me. The only reason the plea has not happened is because we didn't have Mr. McCoy here.
Right.
It wasn't until this morning that I was notified now that Mr. McCoy may not want to proceed. And although that doesn't impact the DV case so much, because we know we have not subpoenaed witnesses based on the assumption that this has been a plea, it's gonna stay a plea, we can get our case pulled together if we absolutely have to. It impacts more so the drug case because yes, all the drugs have not been tested. However, that is typically how GBI handles things. When we know something is going to trial, we go ahead and request that they finish testing, at which time they typically do. But that also means they usually need a 30-day turnaround to do that. So I recognize the other cases, Mr. Jordan's, but again, I know that he hasn't looked at it because we have been under the impression for quite some time. And I think my initial email in reference to this case was back in March. And it's been a plea for every calendar up until we got here today.
Right. In fact, it was maybe even going to be a virtual plea. I'm not following entirely though. Have some of the drugs been tested or none of the drugs have been tested?
Some of the drugs have been tested, just not all of them.
Okay. Is it the same victim across the 2 cases?
Yeah.
No. Okay. And when you say, Ms. Feely, witness issues, as in the state won't be able to find them, or we'd be in a situation like, I'm not going to remember her name, but someone had a client today whose person they supposedly beat up and said, I'm not coming into court. So, oh, Mr. King's Ms. Fuse. Is it more like a Ms. Fuse situation where the victim is saying, I'm not interested in supporting the state's efforts, or you just have a pretty good feeling they'll never find the person?
right, and these are cases both from 2020.
Ooh.
And so I do anticipate that they will have difficulty, 1, locating, and 2, getting under subpoena.
I don't know what, there we go. Okay. All right. So what's changed? Just that you and Mr. McCoy had a chance to look at discovery more. You've had discovery all along. He's looked at it and said.
And we've actually discussed, and I told him what I saw on body cam and all that. And I believe that both of these cases are fairly defensible, which is not something that I was able to get from him over phone calls where he had people in the room with him.
The drug case is a peculiar mix of domestic violence and then a whole pharmacy of drugs and a gun. I'm not asking you to reveal anything beyond just general stuff, but what's defensible about the gun recovery and the drug recovery? Assume that all the drugs are what the police think they are. And I'm going to give the state a chance to test all this. Obviously, Mr. McCoy's not going anywhere anyway, but he's going to stay in Fulton. What's defensible about the seizure of the drugs and the gun?
It's the complaining witness's car.
Okay.
He's just in it when he happens to get arrested, but I think there's.
Is she in it also, or he's the only one in it?
He's the only one in it, but he's not driving it. He's hiding from the situation that was going on.
Okay. The situation that was going on, meaning law enforcement, or there was like a shootout going on in the street?
No, there wasn't a shootout. He was in this car that I believe there's going to be equal access issues and ownership issues that I frankly believe would make this a trial case. But I didn't unfortunately have that conversation with him until last week.
Okay. And the drugs and the gun aren't in a backpack that says Q on it. They're just in a center console or something?
There's a jacket involved, which we can test to, but this could still be a plea. I think Ms. Willingham doesn't have the authority to dismiss counts, was that right?
It is, because this case is a trial line case, it is a trafficking, it is something that typically, yes, in our office, we do need a trial line, we would need approval. And as I did mention to Ms. Feely this morning, that based on just now finding out that it's not a plea, it's not something that I have spoken with my supervisor, nor did I mention to Mr. I didn't even put Mr. Jordan on notice that he needed to.
Yeah.
Based
Okay.
on our thoughts.
Well, it's Monday, and trial's not till next week. So let me say first, I don't expect the state to magically be ready on either of these. But it may behoove you all to look more closely at the file, see if there are things that are modifiable, meaning charges, if that gets folks closer. But Mr. McCoy is the one who's going to be waiting on this because it has been represented as two cases that would work out. We just need to get Mr. McCoy here. And I understand why it's changing. I'm not frustrated with the change in the landscape. It's just, given that it's changing now, I don't expect the state to be in a position, having relied on the representation that these would be pleased to say, oh, we're ready to go. I also don't want to unnecessarily move this case to the front of the line at the GBI to test these things if the debate isn't so much they weren't drugs as they weren't my drugs. And so it sounds like the three of you, or at least Ms. Willingham and Ms. Feely, ought to talk some more to see where this can go. It would be great if we can work it out, but I don't know if this will factor into Mr. McCoy's interest, but he's going to stay here until we work this out. So I don't think that I need to engage Mr. McCoy. This is a different situation from Mr. Barry, where the only thing that's changed is he don't want to take the plea now. But for Mr. McCoy, this has evolved because he's finally had a chance to meet with you directly, and you are better able to process the discovery with his input. This is all very understandable. How do you want to leave things from the defense side with Mr. McCoy?
We are still kind of going back and forth. I just made a counter, but because we do have court later on this week, would it be possible to have him?
Of course. If you let Ms. Nelson know, we are generally able to bring over one more person because some judge who's got slots that day will lend us one. And if it's our day, but even if it's our day and we're full, we can usually scrounge one up from someone else. So, and there's always the virtual option, which may be more acceptable now that you and Mr. McCoy have connected some. But the goal would be to get him here in person. And other judges will be flexible because it's viewed as a trial matter, even though we may be bringing him over for a plea.
He is motivated to get off of our street, so it's not him causing any delay.
No one's causing delay. It's just, it's a shift, and I get it. I just don't want Ms. Willingham and Mr. Jordan to think, oh my gosh, how are we going to get ready for this? The answer is you won't. Try to get ready for a plea. And I guess let's not hit the panic button with GBI until the end of the week, because maybe the case will resolve. If it doesn't, then you will need to get those test results, because we're going to put Mr. McCoy on the next available trial calendar. He may miss one. He will, because June's already been published. So he would make the July calendar. And that'd be more than 30 days. So hopefully the expedited approach with GBI would work and they could test those things. And then you all would know you need to find these witnesses from 2020. Okay, so that takes care of for right now, Mr. McCoy. So let's bring Mr. Barry out and get some things on the record. All right.
Your Honor, briefly on Mr. McCoy, I did reach out to my deputy. We're in the process of talking it out. We may have a counter offer to what Ms. Feely has suggested, but I do believe that by the end of the week, we should probably have that one worked out.
Okay. Are all the numbers we're talking about less than what he's serving on the case that has him in DOC, or would any of these extend his stay?
Sentence doesn't actually change.
I don't,
That our offer was the same, Ms. Feely's just, her question is in reference to charges on.
because of, so that I didn't follow that, because if you plead to something that happened with Mr. Clark, what is the concern?
So just pleading people out to drug cases and gun cases.
Because the second or subsequent can be more problematic.
So I don't do that lightly.
Got it. But Mr. McCoy already has one gun charge from, if I'm remembering the same guy, I think that's what his case was, but who knows? I mean, you guys know, we can look it up. Okay. But that's helpful, Mr. Jordan. So and now I understand what you were saying, Ms. Willingham, that it's not, these negotiations aren't changing the recommendation, they're changing the structure. Okay, got it. That seems like your office should be able to.
Yes, I believe so, Your Honor. I had to explain essentially the same thing that Ms. just explained about the issue with it being the victim's car, but I do believe that we'll be able to work something out. It may not be exactly what Ms. Feely is requesting, but I'm sure I'll have a counter offer that may close the case.
Okay, that would be good. Can you all pop the camera up on that? The top of this monitor, if you sort of mush down, there we go. Thanks. No one's been able to see you.
Yeah, I learned in one of the trials here. Love to see it. I don't think it's really us.
So if Mr. Barry doesn't go forward today, then position 6, I will add to the short list. That's your request?
Yeah.
6, not 7? Okay. I don't have any notes on here. This isn't one where there was medical records or trying to get a lawyer for a witness.
Yeah.
Okay. And whatever offers on the table for Mr. Barry, that makes all three of his cases go away?
Yes.
Give me 1 second. All right. Mr. Barry.
Good afternoon.
Good afternoon. How are you?
I'm okay for the most part.
For the most part. I know you're not in the situation you want to be in. You're in jail. You're wearing the jail clothes. Ms. Feely told me this morning, I think we've worked out Mr. Barry's 3 cases. Now it's afternoon. She said, it's looking like Mr. Barry wants to have a trial, which is fine. You've got an absolute right to trial. I need to get a few things on the record about what things will look like come Monday morning. Okay, you ready to talk about that?
Yes, Your Honor.
Okay. Ms. Willingham, it may be that you and Ms. Willingham is one of the prosecutors on your case. You and Mr. Jordan may share responsibility across the 3 cases, but I'm going to look to you to be the point person. So can you tell me what the state's recommendation would be if Mr. Barry were to enter a plea today?
As to Mr. Barry, indictment ending in 1-8-2437, count 1 would be 5 years to serve 1 year. Count 2 and 4 would be non-prized. Count 3 would be 5 years suspended, and that would be consecutive to the other counts in that indictment.
Okay.
The indictment ending 1-8-4-2-9-5. Count 1 would be 5 years to serve 1 year, and all other counts would be non-prized. As to indictment ending in 1-8-5-8-4-4, that case would be, it's my understanding that Mr. Jordan would actually be willing to reduce that forgery first to a forgery in the 4th degree, which is a misdemeanor.
Yes, that's correct.
And it would be 12 months to serve, and that would run concurrent with all other cases.
Okay, I think I follow all that. Let me look one thing up here. All right. So what that means writ large, if we really distill it, is that it's a 5 to serve 1 balanced probate. I know there's some suspended time because of the gun charge. Mr. Barry's been in for 316 days, so it would be a few more months. At most, he might get paroled out well before then, but it would be a few more months at most, and that would resolve all 3 of his cases. Okay. That offer that is good right now, when does the state take it off the table so that Mr. Barry might be looking at something else if he decides to plead on the day of trial? Thursday. Okay. So Mr. Barry, I want to make sure you heard what I heard. If you were to enter a plea today, the state would recommend that I sentence you to a year to serve across all these cases, followed by some probation. So you wouldn't get out right away, but you'd get out real soon, and you'd have resolved your 3 cases. Is that what you understand the offer to be?
Yes.
Okay. You understand that after Thursday, the state is withdrawing that offer. So come Friday, or more likely Monday morning, because you'll be back here Monday morning, we'll get you dressed out differently. And there are going to be 48 people sitting in the courtroom wondering what they're here for. And I'll tell them what you're charged with. And the state would go forward with the case where you are charged with assaulting Ms. Agnes by hitting her with a gun. Maybe you knocked out a tooth or did something to her teeth. But that situation, which is from December of 21, that's what the state would go to trial on first. That's what the jury would hear about next week. So after Thursday, you could still enter a plea, but the state would be recommending something different. I presume they'd be recommending more, but the state gets to recommend whatever they want. So they might say it should be 1 year and 6 months, or it should be 2 years. This recommendation of 1 year is only good for a few more days. You understand that?
Yes.
Okay. If you go to trial and you are found guilty, the state's going to recommend whatever it wants, but recommendations really don't matter anymore. They matter. I will listen to what the state has to say, and certainly listen to what Ms. Feely has to say on your behalf. But then a jury would have found you guilty, and it's not really negotiating anymore. And I'd be sentencing you based on all the evidence I heard about whatever happened to Miss Agnes in December of 2021. You understand that?
That's a fake name. I don't that.
Okay, I don't want to get into the facts or no facts about the case. It could be that they got the name backwards in the indictment. That happens sometimes. It could be that the last name is Margiana. I don't know. You may have a great defense. That's not the point right now. Right now, I need to make sure you understand what the state's offering, which is not quite time served. It's 5-1. I'm not bound by that offer. I could sentence you to less. I could sentence you to more, but at least you've got the state saying 5 serve 1 today. That may not be what they're saying if you go to trial and Ms. Fake Name comes in here and tells the jury, maybe there's a picture of her tooth missing, maybe you're found with a gun. I don't know the facts, and we're not going to get into those. But if you're found guilty at trial, the state may not be singing that same song of 5 years to serve 1. And if for some reason that trial doesn't go well for the state and it goes well for you, then they've got the next one. And they've got the one after that. So they've got 3 different cases that they could try. We'll do one next week if we don't resolve this by way of a plea, and then we'll keep working through them. I want to make sure you understand what the sequence of events is, so that I'm comfortable that you're making a knowing decision when you say I'm not interested in their offer. Okay. Do you have any questions about
what you just said?
Yeah.
Yeah. See, this is what you just said. So you're saying the sequence of the cases. So after I get to be in front of a jury for the first case, then so beat that or whatever, whatnot, then I have to go to another sequence of beating another case.
Right. I mean, you have 3 cases, and I haven't heard the state say they're going to dismiss anything. What they did do is say, well, we'll give you a consolidated offer. So this plea that we were talking about, the 5 serve 1, that takes care of all 3 cases. Gone. If you beat the case involving Ms. Agnes, whatever her name is, you still have 2 more cases waiting to go through. And we'll get you back in here. It won't be back to back, meaning if you beat this case on Thursday of next week, you and Ms. Feely will feel good about that. And then you'll go back to Rice Street, and we'll figure out a time when we can get you in here for the state to try to prove the next case. And if you beat that one, then you'll go back to Rice Street, and we will wait and see when we can get you in here for the 3rd case.
So what I had to say about that was I've been on the trial calendar since January 5th of this year. And it's like all the cases been just disappearing. I've been like, just wondering like where I'm gonna go to court. I haven't been in court in 6 months. Like, that's the reason why I was willing to accept a plea today. Because to my acknowledgement, it was a go home today plea. But now that I get here to the courtroom, it's like, oh, well, you have more time to spend. But to be honest with you, I have spent over a year in jail on all these cases, and a sequence of different times of being, first I was bonded out by the fake name person, and then it's signed off on the bond because didn't want to, don't want to personal, didn't want to be with her anymore. So that's when she signed off on my bond. I came back in here and I had to do some more time until she signed off on the bond again. Bond me out again. And within those time, that will be well over the time of plus this 10.5 months I just been locked up. So I'm like, I'm feeling like I'm doing time. And I'm just really doing dead time. So.
Well, let me, you're not doing dead time because you're in custody and right now the state's offered this. I don't know what would happen if let's say you go to trial on the first case and you don't beat the charge. This won't have been dead time. It will be credited to the sentence that you ultimately get. I'll tell you, if the jury ends up finding you guilty of hitting someone in the face with a gun such that it knocked a tooth out or chipped a tooth, you're not done with your sentence yet. So you got to work through that. So I've got a Margiana Tillett as the alleged victim in your second case. I'll notice those names the first names are the same. So maybe Agnes and Tillett are the same person. And don't know why it's a different name, but people's names change, and that's not real central here. Mm-hmm. Let me pause our exchange for a minute and ask Ms. Feely. Mr. Berry said something that intrigues me. He believes that if you take the different segments of time he was in before he bonded out for these different cases, he thinks it's more than a year. Have you had a chance to do that math?
I think he is right, but he wouldn't necessarily by law be given credit for the first case towards the second case after he bonded out. But I would also note that he's in a position kind of like Mr. Jones, where he's wants to hear from you that he will be first out on this calendar because I don't think the state can prove these cases, but I'm not in jail having to wait on another court date. So I'm going to respect Mr. Berry's decision ultimately.
Sure.
But it is the same person. So I think if we beat the first case, I don't think the state would proceed again with their same witness.
Okay. Ms. Tillett / Agnes.
And we're happy to plead to the misdemeanor forgery.
Okay. So what I can tell you, Mr. Berry, is that you would be, well, I have to look at I try to do the trials in the order of how long people have been waiting in jail. So I can't say for sure. I know that Mr. Pitts has been in longer than you have. I just don't know about Davis and Richardson. Their indictments are newer, but not by a whole lot. But I can work through that.
Yeah, I could speak. I would like to plead if I would be credited for my time. I would take the plea so I won't have to, because to me it sounds like I'm only be sitting around fighting this case for more time. Then I'll be out before then.
Right. If you took the plea, you'd be out before you would get to your second or your third trial. Okay. Looks like Mr. Davis has been in a little more time, by about a month.
I don't know, I haven't looked at his time, but I will say that is also the case where he has other cases that will hold him in.
You mentioned that. That's right. That he isn't going anywhere regardless of the outcome of the first trial. Okay. So your belief, Ms. Feely, is that if we tallied up all the time Mr. Berry had been in custody in connection with his 3 cases, it would add up to pretty close to a year, or you're looking at it now?
It's still. He also had a probation revocation, right?
Yeah, the revocation was, I went to that hearing earlier last year and it was reinstated, the probation. They were actually wanting to do away with the cases during the probation revocation.
When you say do away with the cases,
Take care of the cases then. That's, to my acknowledgement, that's what they was wanting to do then. But then they just let me bond out again because they said we have no evidence, no anything. So we're just gonna reinstate the probation and the bond that I had, because she had signed off on the bond after I paid the bond. We paid the bond again and I bonded back out. Then I just got, the reason why I was locked up right now in custody is because I was, the court date was sent to my mom's address in Ohio, and I'm on probation currently in East Point. That's where my address is at. 2132 Mulberry Street. That's where my address is at. And I'm on record on file there. And it was a mishap to the address of, and when I got pulled over, stopped, that's when I had this warrant. And I've been sitting in custody ever since. But Miss Feely, last time I went to court was 11/9. It was a status conference. And at the status conference, I really didn't get to speak nothing. I told you what was going on. You said if Miss Feely felt something, she'll put a motion in. She put a motion in. That was on that same day. And that was 6 months ago. That was, now I'm in front of y'all again. But all the court days before then would just been evaporating out the system. And I had a trial. I've been on a trial date since January 5th. So that's why I'm just sitting like, I'm ready to just get it done and over with right now.
Okay, when you say done and over with right now, are you saying as in go to trial or take the plea?
Take the plea. And because to my knowledge, it was, you go take probation. Yes, I'll take probation. And
well, what the state's recommending is that 5-serve-1 balance probated. I don't know what I'm going to do. I have to hear more about the situation, but you know that the state's coming in with 5-serve-1 with credit for time served, but the credit would not include any revocation that you had. The credit would be time that you've been in jail in connection with these charges.
And that was the time I was in connection with those charges. I was locked up.
Okay.
From January 11th, from December 11th, when the case, 2021, from when the case was first allegedly caused, I've been incarcerated since the bond was posted on the 19th of that same month. So that's like 8 days or whatnot.
Okay, you're down to counting individual days. Okay.
Yeah, and okay, that's the first part of it. Then I came in and I sat in on that same case for, let's say it was 3.5 weeks or something like that. And that's when the bond was posted again. And that's when I was just out until the mishaps with the courts sending the mail to the wrong address. And I've been in court.
So we don't send mail to the wrong address. We send mail to the address that you give us in the system. It's not, we don't look people up in the white pages. There's data in the system that says this is this person's address. So I don't know how the Ohio address got in there. I didn't put it in there.
Yeah.
And clearly it was one that was associated with you in some way because it was your mom's address, you said?
Yeah, that's my mom's old address. Like she hasn't been staying there in years. So I don't know how that got on file, but I'm currently on probation and that address is on file. If it wasn't no address on file, that would clearly been a probation violation.
Okay. Well, I don't want to go around in circles with you anymore.
Okay, I'm sorry.
No, I'm not mad.
I'm just trying to.
I got you. And I've heard what you had to say. What you need to figure out is, do you want to go forward with the plea and take care of the 3 cases, or do you want to be on the short list? There are only 4 cases that are possibly going to trial. Only one of them can go for next week. And each one of them, I haven't heard about any issues with yours, but each of the other 3, the potential hiccups as to maybe they can't go. So that's that's sort of where you are. And if you and Miss Feely need to talk a little bit more, that's not a problem. I'll come right back out after you've spoken. I just need to know which way you want to break on this one.
Can I have a split second with Miss Feely?
You can have more than a split second.
Okay, thank you, Your Honor.
All right.
And I have a counter offer I can share with Mr. McCoy while I'm back there as well.
Excellent. I'm going to go back there, check on my kid, make sure he's not tearing up the office, and I'll come back out here when you guys give me the high sign.
Thank you.
Okay.
My math isn't good, Your Honor, but I had a total of 345 days for Mr. Berry. If you total everything up minus the probation revocation.
Okay, I don't doubt that. I just went to this case and clicked on jailings, and I think it said 316 days or something. There ought to be other time out there. I mean, this is one where I think we'll get there, but not my call.
Sure.
So is everyone not moving until June 5 or whatever it is?
I believe so, Your Honor. They put a hold on pretty much everything, including people going back to units that they had already departed from until June 5th.
Huh. That's a little herky jerky, but
It's above my pay grade.
it is. All right, well.
I'm not moving much.
No, I know, that's good. Things are going very well. I have to really kick up a fight. I was like, wait, why is Mr. Jordan going? But you were bumping up, so I didn't want to get in the way of that. The lateral ones are what.
I get to clean up more for Mr. People, so I'm fine with the next 3 weeks.
Ms. Nelson totaled 334 for Mr. Berry. So that's 1 month.
What's going on? I hear a word. What you up? No. Yeah, I think so. We call on Where? On 7 o'clock?
Sorry.
I started to go.
Before we with the reduction in
Okay.
no cost, and Barry is still not listening to me.
Is there any understanding that it's indicted under 133 and not 131 for the possession of firearms that can be displayed?
Yeah, but I mean, it just seems like a lot for.
Well, I mean, that's one that we can get rid of. That's why I said that's a count that would be non-price. But if we move forward to trial, it's one that we not.
Does the jail normally hold them in if they're that close to?
That's what we were just back there with the deputy talking about, because he's gonna be. The deputy thinks he probably will, or Jackson get a GDC number and all that, but I don't know, it's been happening kind of haphazardly.
That seems like such a waste of resources to send them up the road for a week.
Yeah.
2 weeks, so.
What's the, oh,
66, and I can run the
sure. Get it wrong. And we have to go back.
So we just for McCoy, just run with the reduction 2, 3, 2 and 3, 1, 2, 3.
Yes.
We checking so considered so much left over from just the rules, sitting and waiting for the appointment. So, and it was open to them. So. But at least we're only down to a few.
Well, easy for you to say.
Yeah, I know. I'm talking, I have one, all the remaining other ones.
Yes.
But it sounds like it's work out with other stuff.
That's so Richardson. I'm kind of confused about what is motivated to give you to with 2 cases.
It's actually like past Friday. And you just.
Because the one on the calendar alone is pretty straightforward.
All right, Ms. Feely, we'll get Mr. Berry back out here. What does he want to do?
I guess I'm not instilling the confidence of other trial calendars past, and then I think he is going to, once we calculate his time, accept the state's offer and hope that the court does as well.
Okay.
And we're ready to go on Quentin McCoy.
Oh, also,
We accepted the counter offer the state made while we were.
all right.
And Judge, because the counter offer is a little bit different from what I originally did, it's gonna be both me and Mr. Jordan on that one, so that he can, I'm not as familiar with drug trafficking, so he's gonna talk about that one, so he can make sure we have the right code sections and all that.
Not a problem. We've got two microphones, so one of you can be up here and Mr. Jordan, or however you want to do it, as long as Ms. Rivers can hear you. So, Mr. Barry, Ms. Feely tells me that as you sort of weigh the pros and cons and the certainty of going forward today, the uncertainty of going to trial, and the waiting that may flow from that, that you want to go forward with the offer from the state and plead to the three cases. Is that correct?
Yes, Your Honor.
Okay. Then let's do that. Ms. Willingham, if you will come on up to the microphone here. The way this will work, Mr. Barry, is that you're going to be put under oath in just a moment by Ms. Willingham. Once you're under oath, you'll need to answer her questions and mine truthfully and completely. It's important, but I think you're going to be good at it, that if you've got questions because you don't follow what's going on or it's going differently than you were expecting, that you ask Ms. Feely or you ask me. Just say, wait, raise your hand, whatever you need to do, because I need to be comfortable that you are following along with what we're doing. Okay?
Yes, Your Honor.
Excellent. Ms. Rivers, are you ready?
Yes, I'm ready. I'm on the record.
Great. So these are positions 6 and 7 from the trial calendar, 22 SC 182437 and 22 SC 184295. But there's more. There is also 23 SC 185844, which I think is a forgery case that's being reduced, but we are taking pleas on all three. Is that correct?
That is correct, Your Honor.
Okay, great. When you're ready, Ms. Willingham.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, Your Miss.
You can put your hand down. Please state your name, your age, and your date of birth.
My name is Keith Allen Berry Jr. I'm 32 years old and I was born 12/21/1990.
Are you now under the influence of any medicine, drugs, or alcohol?
No,
How far did you go in school?
some college.
Can you read and write in the English language?
Yes,
Have you had the opportunity to review the documents that charge you in these cases?
yes,
Do you fully understand the nature of the charges pending against you?
yes,
By pleading guilty today, you are giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
yes,
The negotiation in these cases as to 22 SC 182437, as to count 1, 5 years to serve 1 year, as to counts 2 and 4, those will be non-pros, and as to count 3, 5 years suspended. And that would be consecutive to the other counts in that indictment. As to indictment 22 SC 184295, count 1, 5 years to serve 1 year, and all other counts of that indictment will be non-pros. As to indictment 23 SC 185844, it would be reduced to forgery in the 4th degree, and that is under code section.
And I apologize, I gave you the wrong code section. It's 16-9-1E.
Under OCGA 16-9
1
E. That would be a minimum of 1 day and a maximum of 12 months. And for that, sorry, I skipped around. And for that charge reduced at the forgery 4th, you would then have a 12 months to serve. And that would run concurrent with all other cases and all other counts. You're pleading guilty today to 2 counts of aggravated assault, each with a minimum of 3 years and a maximum of 20 years. Possession of a firearm during the commission of a felony with a 5-year consecutive sentence, and forgery 4th degree with a minimum of 1 day and a maximum of 12 months. Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
Yes. I'm on probation in Fulton County.
Do you understand by pleading guilty today that your probation or parole will almost certainly be revoked if that has not already been handled?
Yes, I understand.
Do you know the case number? We can get it from Ms. Tucson if you don't have that.
I have it up on my screen right this second, but I can work on, see who have a race here.
Okay.
You heard me tell the court what the negotiation is in this case, which is 10 years to serve 1 year. And that's 10 years because 5 years is suspended. So it's really a 5 year serve 1 with 5 years suspended.
Yes, I understand.
Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which is 60 years?
Yes.
And Your Honor, that number is probably not correct anymore because I originally factored in the forgery first.
Okay.
Do you further understand that you may not withdraw your plea once the court pronounces sentence?
Yes, I understand.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. Under the general conditions, you will be required to follow the general conditions of probation that probation will give to you when you meet with them, including, but not limited to, that you are not to violate the criminal laws of any governmental unit. You are to have, under the special conditions, you are to have no violent contact with Margina Angus / Margina Tillett, complete family violence intervention program, no weapons, drugs, alcohol, complete your GED if applicable, and it is my understanding you have some college, so that would not apply. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes, I understand.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes, I'm entering my plea with an understanding of everything that you just told me.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No, no one threatened me.
Are you satisfied with what your lawyer has done for you in this case?
Yes, Ms. Feely did a good job.
Do you have any more questions for your lawyer before we go on?
No, I don't have any other questions.
Have you understood everything I have asked you so far?
Yes, I understand everything you're telling me.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Under Alford, I entered a plea.
Judge, and I'll read the Alford portion once. Is your decision to plead guilty made freely and voluntarily?
Yes, I'm freely making this plea.
Are you entering your plea of guilty pursuant to North Carolina v. Alford, meaning that you may not admit guilt to every element of the crime charge, but believe it's in your best interest to plead guilty today?
Yes.
Are you a United States citizen?
Yes.
If you wish to challenge this plea for legal error, you have one of 2 ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You will have 4 years from the date the sentence is entered for your felony offenses, and you will have 12 months from the date the sentence is entered for your misdemeanor offenses to file this petition. Do you understand these time limits?
Yes, miss.
Do you understand that you are not allowed to possess firearms during the course of your probation?
Yes.
Do you understand if you are found in possession of a firearm, you could be charged with another felony, which carries up to 10 years in confinement?
Yes.
Your Honor, if the state were to proceed forward with trial in these matters, as to 22 SC 184295, we would prove beyond a reasonable doubt that on June 16th, 2022, Ms. Margina called to make a report for an incident that occurred on June 13th, 2022 at 1935 Allison Court, apartment N10, Atlanta, Georgia, in Fulton County. Margiana told officers that on the night of the incident, her and Barry got into a verbal argument. She stated Barry was drunk and was trying to take the keys to her car. When Margiana refused to give Barry the keys to her car, he got aggressive. Barry put both hands around her neck and began strangling her. When she was able to get away, she ran out the door towards her vehicle. Barry came outside after her and began firing shots at her. One bullet grazed her leg, but did not need medical attention. Margiana acknowledged that there was a no contact order, but admitted that Barry was still living with her because he had nowhere else to go. She also stated that at times she would ask him to leave, but he refused. Margiana told officers she waited 3 days because she was afraid for her safety. She called an ADA from the DA's office, who she worked with on the pending case, and they advised her to call the police. 22 SC 182437, the state would prove that on December 11, 2021, officers responded to 1935 Allison Court, apartment N10, Atlanta, Georgia, in Fulton County. Officers met with victim Margiana. She had a swollen upper lip and her 2 top teeth were chipped severely. She stated that Barry pistol whipped her with a brown handgun. Subsequently, officers returned to the home the next day, at which time Margiana gave them permission to search the home and they were able to locate the brown gun. In indictment 23 SC 185844, on July 16, 2021, Hapeville Police responded to the Imperial Cafe located at 3259 Dogwood Drive, Hapeville, Georgia, Fulton County, in reference to a disturbance call. Officer Zarit met with Reginald Thomas, who owns the cafe, who stated that he was holding defendant Keith Berry, who had just tried to use a fake $50 bill to pay for his food. Mr. Thomas stated the defendant came into the store with a fake bill and gave it to an employee, April Thomas, who then went to the store next door to get change for the fake bill. While April was gone, defendant left the store and didn't return. April tried to catch defendant to tell him the bill was fake, but he walked away from her. Defendant told Officer Zarit that he hadn't been inside the cafe. Defendant said that he went to buy a drink at the Super A Mart, where Reginald confronted him with a $50 bill as he exited the store. Defendant said he didn't stop because Reginald had a gun. Officer Figures checked the store camera and observed defendant sitting at the counter and leaving abruptly. Officer Zarit arrested defendant for fraud. Your Honor, the state has had an opportunity to speak with, well, I have not directly spoken with the victim. However, after diligently searching, I was notified this morning that my victim was served and subpoenaed to be here. She has, although she initially seemed to be cooperative in the second case because she did contact someone with our office, or at least that is the information we've been provided. We were not able to find notes where she did make contact, but we will take the police report as she reported it at that time. And with that, we do believe she was cooperative at one point, is no longer cooperative. It is our understanding that, as was represented by Mr. Berry earlier, that regardless of whether it's a mutual decision that they want to still be together or not, she still would like for them to be in a relationship, and proceeding forward without her, even with the body cam footage, would be rather difficult, as it is not as clear in the body cam footage as we would like for it to be. And with that, that is why the state made the offer. I did pull the criminal history of Mr. Berry, and there is one CWAC case out of Ohio. There is another possession of controlled substance, Ohio. And I'm sorry, the first one is 2004. The possession of controlled substance is a 2010. There's another possession of a controlled substance that's 2014, a possession of cocaine in 2019, a DUI from 2019, and a weapons under disability from 2019. Those are all out of Ohio.
All right. So your office has found, I'm going to call her Ms. Tillett, has found Ms. Tillett, but the exchange that either your investigator or someone from victim witness had indicated Ms. Tillett's not real interested in being involved.
Correct.
And did she say, I want to have Mr. Barry in my life, or you are basing that on the fact that he supposedly chips her teeth in December of 21, fast forward 6 months and they're back
No, Your
together?
Honor, it is, it has been represented to me by my investigator that in their conversation that she has no desire to move forward, that she does have a desire to move forward in a relationship with Mr. Barry.
Okay, got it. Thank you. Ms. Jackson, I heard a fair amount of detail from Ms. Willingham about criminal history. How many cycles do you have for Mr. Barry, and what's his most recent arrest, if you would?
He has 26 cycles, and the last arrest was March the 24th, 2022 in Fulton County for a probation violation. Those underlying charges were possession of Schedule II controlled substance and possession of a firearm by a convicted felon and possession of Schedule IV controlled substance.
Got it. Thank you. Did you find, Ms. Feely, the case for which Mr. Barry is on probation?
Yes, it's 20 SC 176976. And it looks like he admitted for probation purposes and did get revoked already.
In connection with these charges? Okay. Ms. Tucson, do you have Mr. Barry on probation for any other cases?
No, Judge, that is the case he is currently on probation for.
How much time is left?
1 year, 10 months, and 17 days.
Okay. All right. Did we need to talk about offered plea? I'm happy to do that. Is that what?
I've read it, Judge, but I'm not certain. I didn't go into it as detailed as I know you typically do.
Okay. All right. Ms. Feely.
Thank you, Your Honor. I'm pulling up those dates again. So Mr. Barry's 32. He's a father. He has some college under his belt, but the real crux of the issue here is Rice Street has not been good to him, and he is not mentally able, I don't think, to be there much longer. So I believe the relief of having these cases closed and having a date possibly certain of a max out is worth more than letting me fight this at trial. But I know she's been to the complaining witness has been to my office.
What's the last name you use for her? Tillett. Okay.
She's been to my office. I know she went to the DA's office and signed a waiver of prosecution. So I think that this would not go much past next week, but this is Mr. Barry's decision and this is where we are. So we're asking the court to accept the state's recommendation and hopefully let me do some adding of the jailings.
Ms. Nelson came up with 334, but you may be able to find more.
I got it to 370, but these are not, he wouldn't by law necessarily get credit for all of these things. It would be the court's discretion.
Okay.
I'm happy to put those dates in.
You can share them with Ms. Nelson. Mr. Barry, how many kids do you have?
I have 5 kids and 3 children.
Okay. Are any of those kids with Ms. Tillett?
Yes.
Are those the step kids or are those the biological kids?
I have 3 step kids and I have 1 newborn with her.
Okay.
6 months, just turned 6 months. And I have 4 children by another woman.
Okay. And is that someone in Ohio or someone here?
That one is someone, she's be back and forth from Georgia to She'd be back and forth from Atlanta to Ohio.
Okay, where are you from in Ohio?
I'm from Toledo, Ohio.
Okay. So Ms. Willingham talked to you a little bit about an offered plea, which is also called a best interest plea, where a defendant says, you know, I heard what the prosecutor said. That's not exactly what happened. Maybe they got some of it right. Maybe they didn't get much of it right at all. But I, the defendant, want to move forward because it is a better outcome for me to take these pleas than to run the risk of going to trial, or maybe trial's not so risky, but because I picked up 3 cases, I might have a trial and then I'm gonna have to wait some more and have another trial. And so I would rather, meaning you would rather, resolve these cases today, even though you don't agree with everything the state said happened in the 3 cases. Is that a fair description of your situation?
Yes, Your Honor.
Okay, you understand they're still gonna show up as convictions.
I understand that.
All right. Is there anything you want to add beyond what we've been discussing?
Yes. I understand that I'm taking a plea to some stuff that could be that I'm saying that I'm saying that it's in my best interest to take this plea. And I just will ask the state to do some justice there. For ask you to, I know you're a good judge. I know you can then had a lot of cases before you. I know you can see through bull crap, and you know what's going on. So I just ask for some justice. I feel like, to be honest with you, just now it's my time to speak. Like when I wanted to get away from my girl, I was being like, I feel like I was being more entrapped by the system because I'm already a convicted felon, and this is a way that as a power struggle against me. I was put in jail and I was bonded out by the same person. When I got bonded out and I wanted to make my exit route, she signed off on it. And then when I complied back with her, she bonded me back out. And then that's when these cases is like, I'm really trying to, I didn't know how to move about this. I didn't want to leave her, and then she get to cooperating with the state more with bull crap, you know. So
it sounds like the police would have said in the December situation that when they met with Ms. Tillett, she in fact had a swollen lip and her teeth were chipped. What's the bull crap about that?
I really don't know. I really don't know, but I know who I didn't do. I'm just saying I didn't do nothing to her. I didn't pistol whip her. I got pistol whipped before. That's what this scar come from my face, and I know that's where this story came from because I just was going through a broken jaw with her, and I know when I healed up, I was planning on going back. I didn't want to be around my children and they see me like that.
Yeah.
So when I was gonna go back, I was gonna go back to my other baby mama, and she wasn't going for that. So that's what the facts of this is.
Are you saying that Ms. Tillett pistol whipped you?
No, she didn't pistol whip me. This happened. I got robbed.
Okay, you were pistol whipped by someone else.
Yeah, pistol whipped by somebody else. She ain't do that to me.
Okay.
But that pistol whipping came out of what happened to me. It was just I don't know, a fling of how she made a scene.
What about the Imperial Cafe? You saying you had nothing to do with that, or that
I was guilty. I'm gonna tell you that was me. I did that.
You had the bogus 50.
I had that 50.
Okay.
I was hungry and I had to eat.
Okay. All right. So that's not an offered plea. The one about the counterfeit bill. The 2 situations with Ms. Tillett, those are offered pleas. But the situation in Hateville, you own it.
I did that. I did it. And when a man came in with the gun, I tried to, man, I don't know what you're talking about, bro. I tried to ease off, but he wasn't going for it. The lady came back across the street and she pointed me out, and that's when he grabbed me and like, yeah, you ain't going till they come.
Okay.
And I went down.
Got it.
And she bombed me out for that too.
Ms. Tillett did?
Yes.
Okay. Does she work?
Yes, she works.
What does she do?
She's a home health aide assistant. Like she have different clients that she do.
Okay. And before you got locked up, what were you doing?
I worked it for the Marriott Grand Marquis downtown, the banquet.
Okay. How long had you been doing that?
I work for a temp service and they give me different assignments. So
You'd go to each assignment.
Yeah, I was there for a little bit before then. I was at Peachtree Publishing over on Marietta Street, like kind of around the corner from the jail. And before then, I was working construction in Buckhead. I always keep an assignment to work.
Okay, so those 3 different jobs were all through the temp agency?
Yes, this temp agency, they keep me lined up with work.
Okay. All right. Anything else you want to add?
Yes, I write books. I got a lot of stuff going on. Oh, I thought I could tell you what's going on with me.
Oh, no. I meant more about these cases.
Oh, no, ain't nothing. This is me and the mother of my children. You know, it's just a family, some misunderstanding that we need to, them family classes will be, the domestic violence classes, we need to go ahead and get them, get that.
All right. Well, Mr. Berry, I find that there is a factual basis for each of your 3 cases. I understand that both you and Ms. Feely believe that the facts aren't so strong for the state in the 2 domestic violence cases. But if the state were able to present the evidence that Ms. Willingham described, a jury could believe that version of events rather than your version through Ms. Feely. And if they did, then they'd be authorized to find you guilty. I'm not saying that's what would happen, but it could, and that would be a valid verdict. And then the counterfeit bill one sounds like you know what the situation was there. I also find that your pleas are knowing and voluntary. Voluntary means that while you're not real enthusiastic about your situation, you've decided that moving forward by pleading guilty is in your best interest. Is that correct?
Yes, Your Honor.
Okay. And knowing just means you don't have any other questions about the things we've discussed. Any other questions?
No, I haven't no other questions.
Okay. Well, if anything comes up while I'm talking, let me know. I'm sentencing you pursuant to the Probation Options Management Act, such that while you are on probation, if you have a minor violation, you and probation will address that. If it is more serious, you get arrested again, or you violate one of the special conditions I impose, then you'll come back to me and we'll figure out what's going to happen. Do you, Mr. Berry, authorize my staff to sign your name on the 3 indictments indicating your guilty pleas?
Yes, Your Honor.
Ms. Feely? Yes, and Ms. Willingham?
Yes, Your Honor.
All right. In 22 SC 182437, on count 1, I'm going to sentence you to 1 year to serve. On count 2 is dismissed. Count 3, I'm sentencing you to 5 years probation. So it's a sentence of 6 years to serve 1 year, balance probated. You'll get credit for all the time you've been in. Ms. Feely is going to provide some dates to my staff. My staff's already come up with about 335 days. So you're a month at most away from 1 year, and you may be past it. We'll look at the numbers Ms. Feely shares, and then I'll work through that. In the case of 22 SC 184295, your sentence as to count 1 is 6 years to serve 1 with the balance probated. Again, credit for time served, and that will run concurrently with, at the same time with, your sentence in the case ending in 437. All other counts in that indictment are being dismissed. And finally, in 23 SC 185844, that's the Imperial Cafe fake $50 bill case. The state has agreed to reduce that to a misdemeanor, 16-9-1E, which is forgery in the 4th degree. And in that, I will sentence you to 12 months to serve. And that sentence will run concurrently at the same time with your sentence in the other 2 cases. I am making it a special condition of your probation in the case ending in 437 and in 295 that you have no violent contact with Ms. Tillett. It would be a crime anyway if it's violent contact. But because I'm making it a special condition, even if it's only, and I put that in air quotes, a battery, it's not something real serious, that would be violent contact, which would mean if the state could prove it in a revocation hearing, I could revoke all of your probation, not just 12 months because it's a misdemeanor, but all 5 years of your probation. I'll also make it a special condition of your probation that you complete a family violence intervention program. Those are your DV classes you were asking for. It's a series of classes that should make it easier for you to work through some of the conflict you encounter because life is complicated. You got 2 mothers of kids and that can create tension. And you need a way of working through it such that the police don't get called on you, because you now see what happens. If Miss Tillett's feeling a certain way and says certain things on the phone, you're going to get put in handcuffs and led away. But the more you can help her work through things so she doesn't do that, hopefully the more fair outcome for you. I am sentencing you a little bit differently than what had been structured because I don't believe in 10-year probated sentences. That's too long, but I want sort of the maximum window, which for me is about 5 years, to work with in case you're not turning a corner yet. I'm hearing you say you want to get out and be there and take care of your kids, step and otherwise. But if you are messing around like this again, I want to be in a position that I can say, I don't even care what the new charges are. I'm going to revoke 3 years here. And so that's why I added a little bit more probation. I think the 1 year part is reasonable, and you've effectively done a year. Either you're right up against it, or as I said, if Ms. Feely identifies windows that my staff can verify, maybe you've done that year. So if you don't get out this week, you're getting out in the next few weeks. They may not even ship you down the road, because why do that if you're going to get out? I don't control any of that, so I don't want you to bank on it. But you should bank on the fact that you'll get out in the next few weeks. I do want to add, as a condition of probation, that you stay away. Is it called the Imperial Cafe? Is it still there?
No, they closed. I see
They went out of business because you gave them a fake bill.
Oh,
But they're not there anymore.
yes, sir.
Okay, so we can't say stay away from there. All right, then never mind. Ms. Willingham, anything else in connection with these cases?
Nothing further, Your Honor.
Ms. Feely? You'll get to Ms. Nelson, the date ranges? Okay, so Ms. Nelson is my sentence writer. She's the one who will confirm those date ranges, and she may have missed one range, or she may have seen it, but may say, you know what, I don't think that qualifies because it was a revocation or this or that. Speaking of which, we don't need to worry about a revocation. You think it was a revocation for all 3 of these situations? Because I'm happy to protect against that right now.
I think it maybe was not.
Okay. I'm happy revoking 6 months, giving him credit for the time he served and reinstating the balance on that case ending in 976 as to convictions in all 3 of these cases, just so Mr. Berry doesn't get grabbed by a surprise warrant somewhere.
Appreciate it.
Okay, you are waiving his due process notice rights? Okay, so Mr. Berry, because you have pled guilty now in these 3 cases, I'm going to revoke 6 months of your probation in 20 SC 176976. You'll get credit for the time you served, and then I'm reinstating the balance. So you're going to have a little more than a year left of probation on that one. Then that one will be done. Your longer window will be for the 2 new cases. They're not so new, but new enough, involving Ms. Tillett. Okay? So there shouldn't be anything else holding you in. There shouldn't be a new warrant from that old case because of what we just did today. Ms. Tucson, you want to talk with Mr. Berry briefly about reporting?
Sure. I am looking at the address that we have on file. Mr. Berry, you know where the probation office is in Atlanta?
Yes, miss.
Okay. The address that I have here for you is a Mulberry Street address. Is that correct?
Yes, miss.
Okay. Phone number 404-707-7097.
It's off right now, so I don't know if they give me the same number or not.
Okay. Just make sure that when you are released, depending upon the time, that you do report to probation. Do you, will it be within the next, Will it be within the next 2 weeks or will it be a little bit longer than that?
Unclear at this
Ms.
point.
Feely?
I'm not sure that we have come to a full decision about that.
Okay, because I would say 48 hours if it was, within 1 or 2 weeks. But so we'll just go with that 48 hours upon release.
Yes, I understand.
To Fulton County, and these dockets will be uploaded.
Okay. I think that's it. Mr. Barry, you've got many years ahead of you. I hope that you are in a position to have things work out a little bit differently. I know you haven't had a good past year, and hopefully that'll be an incentive, just memories of what it's been like to say, it's not worth it to scrap with you, Ms. Tillett. I'm gonna come back in a couple of days because we're both mad at each other right now. And hopefully that works out. Okay.
Yes, Your Honor.
All right.
You're a fair judge.
Thank you, Mr. Barry. Remember that. Fair judge. Heard it here first. So Mr. McCoy is ready also? All right. If you need a water break, let me know. It's been a plea-a-palooza today.
I just need to do more than just keep one.
Yes.
And I did see that case.
Yours has the.
Which?
It's Caleb Caleb Jackson, the one that was gonna pull.
Oh, yes. Yes, it did. That was my birthday present from Mr. Abate. Yes, sir.
And Judge, whenever you're ready, as part of the global plea that both ADA Willingham and I and Ms. Feely have for Mr. McCoy, I will be handling 22 SC 184657. And on that indictment, Your Honor, Mr. McCoy has agreed to enter a guilty plea to counts 1 through 3. And the state will be moving to reduce count 1 from trafficking to possession with intent to distribute 16-13-30B.
B Bravo?
Yes, sir.
Okay, and 4 through 7 will be null prost?
Yes, sir.
All right. Well, let's get on the record. Hello, Mr. McCoy.
Hey, how you doing, Your Honor?
All right, it's been a minute.
Yes, they have.
Welcome back. Mr. McCoy, Ms. Feely tells me that with that announcement about certain counts being dismissed, you're prepared to move forward with guilty pleas in your 2 cases. Is that correct?
Yes, I am, Your Honor.
Okay. Well, you are here. Where did we pull you from? What facility were you at?
Washington State Prison.
Okay. You are here from Washington State. Ms. Feely is here with you. And Ms. Willingham, will you be chiming in during the plea colloquy?
Yes, Judge, to make it easier, and I can go ahead and let you know that the negotiation as to 22 SC 184536 is going to be 5 years to serve, and that will run concurrent with anything in 22 SC 184657.
Okay, got it. Ms. Feely, what is, if you know, the case that Mr. McCoy is serving time on now?
It is a Cobb County case. Don't believe I have that case number handy.
Okay, you don't need, I thought Mr. McCoy had a case from Fulton County, Cobb County. That's what sent you. Okay, fair enough. So, Mr. McCoy, in a moment, Mr. Jordan's going to put you under oath. Then he's going to ask you questions about your rights, things like that. Ms. Willingham will be chiming in from time to time. She's the prosecutor on one of your 2 cases. While we are doing all that, if anything comes up that is confusing you or is not making sense or is different from what Ms. Feely had been talking to you about, will you let me know so we can work through what your concern is?
Yes, Your Honor.
Okay, great. When you're ready, Mr. Jordan.
And Your Honor, I apologize. Ms. Feely, was it 10 to serve 5? Was that or was it 15 to serve 5?
It was 10 to 5.
10 to serve 5, okay. Yes, Your Honor, the state's ready to proceed.
All right, let's do it.
Mr. McCoy, can you please raise your right hand? You swear or affirm the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name for the court, please?
Quentin Deshaun McCoy.
Thank you. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, I'm not.
Is there a medication that you normally take that you have not been given today?
No, I don't.
How old are you and how far have you gone in school?
To the 11th grade, and I'm 34 years old.
Okay. Are you able to read, write, and understand the English language?
Yes, I am.
Do you understand that you have been charged with the following offenses? And I'll start with the indictment ending in 657, and then I'll ask Ms. Willingham to chime in. You have been charged with the offenses of possession with intent to distribute, aggravated assault, family violence, and terroristic threats.
Yes, I do.
Okay. And Ms. Willingham?
Yes, as to indictment ending in 184536, you have been charged with battery, family violence, subsequent conviction.
Yes, I do.
And do you understand that you have the right to plead either guilty or not guilty to these charges in these two separate indictments? And if you pled not guilty or remain silent, you would receive a jury trial?
I do.
Have you had enough time to speak with your attorney, Ms. Lee Feely, about all of the facts and circumstances known to you regarding the charges in these indictments, including any potential defenses?
I have.
Do you need any more time to discuss the case with your attorney?
I don't.
Are you satisfied with her services?
I am.
Do you waive, I'm sorry, Ms. Feely, do you waive formal reading of both of these indictments?
Yes.
Do you also waive any and all defects in these indictments, including any with respect to Mr. McCoy's name? Mr. McCoy, do you recall having been arrested on these charges in these two separate indictments?
I do.
Your Honor, the state is unaware of any outstanding warrants related to these charges. Ms. Feely, do you know of any outstanding warrants that are related to these charges?
I do not.
And beginning with the indictment ending in 657, Mr. McCoy, has your attorney advised to you the minimum and maximum sentence for each charge that you are pleading to?
Yes, yes.
Okay. And for the other indictment, has your attorney advised to you the minimum and maximum sentence for each charge that you are pleading to?
Yeah.
And Your Honor, for the indictment ending in 657, count 1, which is being reduced to possession with intent to distribute, Your Honor, it is listed as ecstasy on the indictment. So that is a Schedule 1 drug. The drug labs actually did come back with 44 grams of methamphetamine, but due to count 1, I wouldn't want to reduce it to a schedule that it was not originally charged as. So for Schedule 1, the minimum is 1 year and the maximum is 10 years. For aggravated assault, family violence, the minimum is 1 year and the maximum is 20 years. And for terroristic threats, the minimum is 1 year and the maximum is 5 years. And I will defer to Ms. Willingham on the next indictment.
And Your Honor, as to indictment 22 SC 184536, battery, family violence, subsequent conviction, the minimum is 1 year and the maximum is 5 years.
Thank you.
Mr. McCoy, do you understand that this is a global negotiated plea of guilty, which means that the state will recommend to the court the following sentence? On the indictment ending in 657, the state's recommendation for count 1, which is being reduced to possession with intent to distribute, will be 5 years to serve to run concurrent with his current Cobb County sentence. As to count 2, the state's recommendation will be 10 to serve 5 to run concurrent with count 1. The only condition of probation, Your Honor, would be that Mr. McCoy have no violent contact with Ms. Brashay Ware, and that's Brishay, last name Ware, Ware. She did contact the office and she actually did not want to proceed forward on the charges and said that the whole situation was a misunderstanding. So we would ask that it be a no violent contact provision.
Ms. Ware is, I'm not remembering, I know we talked about this with Ms. Feely. Ms. Ware is not the victim in both, or she is the victim in both?
I do not believe she's the victim in both.
She is not the victim as to indictment ending in.
You can tell me when we get there,
4, 5, 6.
but the no violent contact with Ms. Ware really would be limited to 657. When Ms. Ware says it's a misunderstanding, as in these were my drugs and you should prosecute me, or the violence part of it was a misunderstanding?
Specifically to the violence, Your Honor, with the
Okay.
things that I had in the file. The last time that we had contact with Ms. Ware was November of 2022, and she has since stopped responding to our calls.
Okay.
As to, and Your Honor, it will come through the facts that, or at least Ms. Ware states that she and Mr. McCoy share a child together, and just to put that on Your Honor's radar, as the facts will show. As to the terroristic threats, the state's recommendation is 5 years to serve to run concurrent with count 1. And I will defer to Ms. Willingham on her recommendation for the battery family violence case.
Yes, Your Honor. And the state's recommendation as to the battery family violence in indictment ending in 4536 is 5 years to serve, and that would run concurrent with indictment ending in 4657. As to the special conditions, the state would ask for no violent contact. No contact, Your Honor, with the victim. And let me go back to the police report. Her name is Tasha Thomas, and Your Honor, in the last note, it shows a former ADA was able to speak with Ms. Thomas, so I am asking for no contact. I do not know whether she has had contact with the defendant since then, so if defense has something different, I would defer to the court in terms of whether that contact is actually wanted or not.
Okay, well, we'll work through it. There's actually no probation in your sentence, so there are no conditions of probation. I could weave it into the probation for the case ending in 657, although I also need to understand how long Mr. McCoy expects to be in state custody, because I'm making it up, but he's got a 20-year sentence. His probation will have ended long before he gets out.
Correct.
So,
but other
we'll
than
work through
that, because we would have no probation on the end, is outside of no contact with Ms. Thomas, we would not be asking for any other special conditions.
Okay.
Mr. McCoy, do you understand that the court does not have to accept that global recommendation for both of your cases?
Yes, I do.
Do you understand that the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other?
Yes, I do.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
I do.
And you are currently serving a sentence for another case, is that correct?
Yes, that's correct.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, I do.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, I do.
Are you a United States citizen?
I am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
I do.
Do you understand that your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, and your right to receive, possess, or transport a firearm, and finally, your ability to obtain employment?
I do.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
I do.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
I do.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
I do.
Do you understand that by pleading guilty, you were giving up the following rights, which I will now list off: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
I do.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Mr. McCoy, how do you plead to the charges of possession with intent to distribute, aggravated assault, family violence, and terroristic threats in indictment number 22 SC 184657?
Guilty.
And Ms. Willingham?
And Mr. McCoy, how do you plead as to the charge of battery, family violence, subsequent conviction in indictment 22 SC 184536?
Guilty.
Are these guilty pleas freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
And I believe, as these are all misdemeanors, all felonies, you have only 4 years from today to file a habeas corpus petition challenging the voluntariness of this guilty plea.
I do.
And do you understand that you only have 30 days from today to file a direct appeal?
I do.
Thank you. Your Honor, beginning with the facts for the indictment ending in 657, on December 30th of 2020, officers from the Atlanta Police Department responded to a domestic dispute with a weapon at 552 Parkway Drive Northeast. Upon arrival, the officers spoke to the 911 caller, Ms. Brashay Ware, who stated that the father of her daughter, later identified as the defendant, put a gun to her head after a verbal dispute over their child and was at that time hiding in her vehicle behind the apartment complex. The officers approached the vehicle with their weapons on the low and ready position and witnessed a person laying down in the back seat of the vehicle who appeared to be hiding inside of Ms. Ware's vehicle. They then did discover the identity of the individual was, in fact, Mr. McCoy. There was a weapon that was found in the floorboard of the back seat on the driver's side. There also was a black jacket that Ms. Ware later identified belonging to Mr. McCoy. In the jacket pocket was an orange empty prescription bottle with no label containing 22 pills of oxycodone, a green bottle of Nature's Way, which contained 25 pills of Adderall. Also inside a children's sock, there was 52 grams of ecstasy in crush form in a clear bag. Mr. McCoy stated that the gun and the drugs did not belong to him after he was read his Miranda rights. Ms. Ware did fill out a witness statement form stating that Mr. McCoy put a gun to her head and threatened to kill her after refusing to leave her house over a verbal dispute on issues with their child. Your Honor, as previously stated, and I need to actually, Ms. Ware stated that things got out of hand is exactly what she said the last time that the state spoke to her, but she did make it clear that she did not want to proceed forward on the charges. From what Ms. Feely was stating earlier before we were on the record, we do understand that this was Ms. Ware's vehicle. Even though she identified the jacket as Mr. McCoy's, we understand that there's a pretty plausible argument for constructive possession, given that it is clearly Ms. Ware's vehicle in this situation, but we do believe that this is a fair negotiated resolution, Your Honor. So I will defer to Ms. Willingham on her facts for her case.
All right, Ms. Willingham?
Yes, Your Honor. As to indictment ending in 4536, on May 22nd, 2020, at approximately 12:47, Officer W. Hanks responded to a dispute call at 3540 North Camp Creek Parkway Southwest, apartment N7 in Atlanta, Georgia, Fulton County. Upon arrival, Officer Hanks met Officer Richardson, who was first on scene, who stated she had made contact with the victim, Miss Tasha Thomas, who stated her sister dropped off her some bins to move. Ms. Thomas stated her oldest daughter went downstairs to retrieve the items. Ms. Thomas stated that her kid's father, Mr. Quentin Thomas, would not allow her daughter in the house with the bins. Ms. Thomas said she attempted to help her daughter bring in the bins. Ms. Thomas stated that the two began arguing about her going to hang out with friends, at which time she stated that she was about to walk out the front door, and Mr. McCoy pushed her to the point where Ms. Thomas lost balance and fell into the TV stand, which caused her to have visible red bruise marks on her midsection of her back. A photo was taken of Ms. Thomas's injuries. And Your Honor, it looks like the last time we were able to actually speak with Ms. Thomas was back in March of 2021. We have made multiple attempts to talk to her since then. We do know the numbers that we have are good. She just will not respond to us.
Do you have anything in your file indicating, I know we already touched on this, I'm just wanting to put the final point on it, her view on continued contact with Mr. McCoy?
In March of 2021, she stated that she wanted no future contact.
Okay, got it. Okay. Ms. Jackson, good afternoon. Thanks for hanging with us. What can you tell me about Mr. McCoy's criminal history?
Yes, 29 cycles. The last arrest was November the 14th, 2020 in Sandy Springs, Georgia, for a fray. There was no disposition for that arrest. The defendant does appear to be on probation in Cobb County for possession of methamphetamine and possession of marijuana with an intent to distribute. That disposition date was April the 29th, 2021, and the term is for 10 years. The defendant does have prior felony convictions. This one in 2017 for possession of a firearm by a convicted felon. This one in 2007 for robbery and possession of a firearm during commission of a felony. And the defendant does have misdemeanor convictions. This one in 2019 for unauthorized discharge of a firearm within 50 yards of a public highway. And there was one in 2017 for disorderly conduct, and one in 2016 for giving false information to an officer, and one in 2015 for driving without a valid license. The defendant does have a history of probation violations. There's one in 2020, there were two in 2019, one in 2017, and one in 2016. Nothing in addition, Your Honor.
Thank you, ma'am. Ms. Tucson, Ms. Jackson mentioned Mr. McCoy maybe being on probation out of Cobb. What information do you have for him?
For the Cobb County case, it states that he is a inmate for that particular case, but he does have the docket for probation, and when he's released, he'll be on probation.
Okay. Meaning he is in cut. Well, I guess Ms. Feely can clear it up. I don't know if he got revoked and he's in on that, or he got a sentence out of Cobb that was serve some time and then do probation. I just want to understand how much more time Mr. McCoy is expected to be in custody. But let's hear from Ms. Feely.
Yes, because I think the wrapping these cases up may have an effect on whether he is eligible to parole out. Mr. McCoy is 34 years old. As you heard, he's a father. He does have children with both of the complaining witnesses. So we would like, of course, no violent contact, but maybe contact only for purposes of the child. Mr. McCoy has been a great client, like he's almost too easygoing with this situation. And I know it is because he is sitting on a sentence with Department of Corrections, but once he got to Rice Street and we were able to meet, I think he's comfortable handling this way, and we would ask the court to accept the pleas as negotiated. He didn't want to end up being eligible for parole and then this affecting whether he could get work release or some other help to get on his feet, because that is what he needs and intends to do. So we are asking the court to consider waiving his probation fees for the first 6 months or so, because this will have been a long time. And we would also ask the court to give him credit from December 3rd of 2020. He was only in Rice Street from then to June 2nd of 2021, but that's because he went directly into Department of Corrections.
Because he went from, so December 3rd would have been when he was arrested on one of these cases. The one involving Ms. Ware, no, Ms. Thomas.
Your Honor, I had my arrest date as December 3rd, and that would be with Ms. Ware for the aggravated assault offense.
Ms. Ware is hiding in the back of her car. Okay, got it. You're right. And so then he went to Cobb, and what happened in Cobb? Was it a revocation or he pled guilty to charges in Cobb?
Because the DOC records show that he actually got there the day he was released from here. So I'm not sure procedurally how he is, but he is sitting on a sentence according to the DOC website, and he has a max out date of August 4th of 2025.
Okay, got it. Why are you in custody now? Did you get your probation revoked or you pled guilty?
I got the case in Cobb. I was out on bond for the case in Cobb. Then I caught the case with Brochet.
Right, lying in the back of her car.
And while I was here, they took me to court for Cobb by Zoom, and I pleaded out to the court. I pleaded out to 5 years.
Okay, to what? What was the charge?
Felony obstruction.
That's it?
No, it was some
Traffic violations as well, suspended license.
But the felony was obstruction?
It was initially aggravated assault on the officer, because he said I hit him with the car or whatever, but there was no proof of that, so they dropped it down to a felony obstruction.
Okay, got it. So that's why you're at Washington State right now.
That's correct.
Is the Cobb case. You were on bond. You get scooped up for the Ms. Ware situation, and you resolve your Cobb case virtually, but they gave you 5 years to serve.
That's correct.
Okay, and then you got sent down the road. We pulled you back to take these pleas.
That's correct.
Okay, understood. All right. Do you have any questions about anything we've talked about?
No, I don't, Your Honor.
Anything you want to add?
No, I don't.
So Ms. Feely was suggesting that maybe you should be able to have some contact with Ms. Thomas when you get out, because you all have a kid, one kid, multiple kids.
That's what I was going to say. I did want to add that. Yeah, I got 2 sons with her.
Okay. So Ms. Thomas, 2 boys, and then how many kids with Ms. Ware?
A daughter, just one daughter.
1 girl. All right. Other kids out there, or you just have 3 kids?
Just 3.
Okay. And so you would like the ability to interact with Ms. Thomas, at least to have access to your boys?
That's correct.
What are their ages?
6 and 7.
And your daughter?
10.
Huh. So you've known Ms. Ware longer than Ms. Thomas?
That's correct.
Okay.
And Your Honor, if I may, per our notes, it says that Ms. Thomas was open to third-party transfer.
Okay. And that's what we'll do, but it does mean that people will be contacting Ms. Thomas on Mr. McCoy's behalf. So if I say no, I just wouldn't want Ms. Thomas to be able to say, hey, I got a text from Mr. McCoy's aunt saying that he'd like to be with his boys this weekend. Those are the okay kind of communications.
Correct, Your Honor. I would ask for no direct contact.
Okay, got it. All right, Mr. McCoy, I find there's a factual basis for your pleas in both cases. Now that I've heard a little bit more about the circumstances of you being in the back of Ms. Ware's car, I can understand why you'd want to work it out. I understand the equal access, but where the gun was described being found and the jacket and all, I don't know that it necessarily goes so well for you, but it could. I also find that your pleas are knowing and voluntary, meaning with the voluntary side that no one's forced you to enter these pleas, but you're doing it after you've had a chance to consult with Ms. Feely and you've decided that it's the right way forward for you to plead in the two cases. Is that correct?
Yes.
Okay, and a knowing plea just means you've understood the things we've talked about. I asked you if you had any questions. You said you didn't, so I'm going to take you at your word. You will have some probation on one of the cases. So I am sentencing you pursuant to the Probation Options Management Act. All that means is that while you're on probation, if you have a minor violation, that's something that gets addressed through probation. You don't come to court. If it is a more significant violation, meaning you get arrested or you violate one of these conditions I'm imposing, then that'll come to me and we'll work through that. Mr. McCoy, do you authorize my staff to sign your two indictments indicating your guilty pleas in those two cases?
Yes, I do.
Ms. Feely?
Yes, Your Honor.
And Ms. Willingham?
Yes, Your Honor.
And Mr. Jordan?
Yes, Your Honor.
All right. Mr. McCoy, in the case 22 SC 184536, that's the situation where you and Ms. Thomas got into an argument. She says you shoved her into a TV stand. I'm going to sentence you to 3 years to serve. You will, in that case, get credit from, I guess, December 3rd of 2020. That will be followed by 2 years of probation. So it's a 5 to serve 3. I don't know that you'll ever be on probation in that case based on the sentence I'm going to give you in the other case. But it will be a special condition of probation in that case that you have no direct contact with Ms. Thomas. So if you're arranging to see your two sons, you'll need to work through a relative of hers or a relative of yours or a shared friend so that you can arrange for a way to spend time with your boys. Does that make sense?
Yes, I do, Your Honor.
Okay. In the case of 22 SC 184657, your sentence, I'm trying to work through the count one where it was meth and not ecstasy. It's not one of the demurs is if you could admit to the charges, everything charged and not be guilty, it's a problem. But he couldn't admit to possessing lots of ecstasy. That would be a crime. But it wasn't ecstasy, it was meth. You didn't have a way to file the type of demur that would address, well, wait a minute, I don't even know that it's a demur. It alleges ecstasy rather than meth. I appreciate the state saying we'll go with Schedule 1, even though meth is not Schedule 1. What are your concerns about this? Because another workaround would be then plead to the possession of the Adderall, which is a Schedule 2. But I'm okay going forward with it if you.
I mean, I think it is legal fiction and I'm not super comfortable with it.
Right.
We would be fine with doing I don't think it changes anything to do the Schedule 2.
I'd be more comfortable with that as well. I don't know what the range is. It's not going to change the sentence because the aggravated assault is going to get I think 10 serve 5 is an appropriate sentence and I'm going to do that. But I get uncomfortable when it's 5 pounds of meth. Everyone knows it's 5 pounds of meth, but the state says we're going to treat it like it was under 400 grams. So and I get that, another legal fiction, but at least you're moving in the same category and you're going to say, we're going to only prove up for purposes of the plea 399 grams of methamphetamine. Here, there was no ecstasy. There was methamphetamine, which is frankly worse for Mr. McCoy if you re-indicted. I'm not saying anyone needs to do that. But what if we worked with either count 4, the oxycodone, or count 5, the Adderall Schedule 2.
In adding that, Your Honor, I just want to make sure that you're clear that
It would be null prosing count 1 because there was no ecstasy. And then, but there would still be a plea to a controlled substance. It would just need to be count 4 or count 5. So the oxycodone or the Adderall. It's not going to change the sentence because, again, aggravated assault gives the range that's necessary here.
the only issue, Your Honor, is that because trafficking is such a serious offense, to see it null pros on an indictment, and I do understand the concerns with it as far as it being alleged correctly, is that perhaps if we just amended that, or the state could proceed forward on the possession with intent to distribute with the Schedule 2, if that makes everyone pretty much clear on that phase, Your Honor. I just have issues with completely dismissing that count, but I do understand if the issue with that count legally.
Right. No, it's a serious allegation, but it's one that you couldn't prove because it's not ecstasy. So I understand why Ms. Feely's not making waves here. I'm the one making waves because 1, you reduced it, and 2, you're not saying, oh, we should re-indict and move forward that way. And yes, there's still the equal access situation that could be litigated before the jury. But I don't want to set a precedent of taking a plea on a count that would be impossible to prove. So I guess if it were reduced to possession with intent, and then it was whatever letter corresponds with Schedule 2, then I'd be willing to do that, because then the defense would effectively be agreeing to amend. It's not reducing, it is reducing, but it's also amending count 1. And I've done that in a plea before, but at least then we're talking about the right schedule of drugs.
And the range still fits it, Your Honor, but it is a 5 to 30 range for a Schedule 2, but that's what the state would like to proceed forward on, if that's fine with Ms. Feely and Mr. McCoy.
So we're clear, that is a more severe sentencing range, but I've already shared what I intend to do. So it's not going to change the sentence that I impose. And this is not a first offender, so it's not that 2 years from now we could go back and say, oh, but that range was 5 to 30. But I think it makes count 1 as amended actually connect to evidence as opposed to what was alleged.
Agreed, Your Honor.
You all right with that?
Yes.
So what is the subsection?
Your Honor, I believe it's still B. It
Okay.
just goes down to a different subsection when with the drug alleged. So
Okay.
it's still 13-30B, I believe.
Okay, B Bravo. And then what Ms. Nelson would put, because she's have to type something in different anyway, because it was trafficking, which is a different section. She would do possession with intent, methamphetamine.
Yes, Your Honor.
And it's still that subsection. Okay. All right. Going back to the part you care about, Mr. McCoy, I'm going to sentence you on counts 1 and 2 to 10 years to serve 5 years. Count 3 would be 5 years to serve. All those will run concurrently with each other, and that sentence runs concurrently with your sentence in the case ending in 536. You'll get credit for time served from December 3rd of 2020 through now in connection with that sentence. Special condition of your probation number 1 would be no violent contact with Ms. Ware. And number 2 would be no direct contact with Ms. Thomas. And I will waive your probation supervision fees for the first 6 months after you get out. You will be reestablishing your life and looking for work, et cetera. And so I'll let you focus on spending your money in that way as you earn it. Any other conditions of probation you were looking for, Ms. Willingham?
No, Your Honor.
Mr. Jordan?
No, Your Honor.
All right. Ms. Feely, anything else on behalf of Mr. McCoy?
No, Your Honor.
Mr. McCoy, any questions about any of this?
No, Your Honor.
Okay.
Judge, I have a question. I'm sorry to interrupt.
No, please ask.
On position number 26, the case ending in 536, what was the sentence again? Can you repeat that?
That was 5 years to serve 3 years with the balance probated.
Thank you.
Sure. And just so people aren't mystified, as family violence batteries go, that one was fairly minor, and I just wasn't comfortable saying I'm giving you the highest possible sentence you could get for that. It's not saying that what happened was good. It's just saying that what happened wasn't nearly as bad as some of the family violence battery stuff we see. And just in case something funky happens with the case ending in 657, that also gives Ms. Thomas 2 years of when you're out, the way you interact with her is indirectly. So I'm just trying to honor her request there. All right. Anything else, Ms. Nelson?
No, Judge.
Okay. Ms. Tucson, do you need any information from Mr. McCoy? He's going to be under a custodial sentence for a little while longer.
I will just put everything into the system, and they will give him reporting instructions from whichever facility he will be released from. Mr. McCoy, do you know where probation is in Fulton County?
Yes, I do.
Okay, they will give you reporting instructions to report there. And will you be living in Fulton when
Yes, I
you are?
will.
Okay, then that's where you will need to report.
Okay.
All right. I think that's it. Thank you.
Thank you, Your Honor.
You're welcome. Thank you, Ms. Jackson. Thank you, Ms. Tucson. And thank you, Ms. Rivers. We covered a lot of stuff. And thank you, Ms. Nelson, for all those final dispositions.
Hey, Judge, have a good
Thank you,
night.
Judge.
Bye-bye.
I will end this in